No.
Get in there though.
Oh God, please don't turn my phone to TV too. Oh God,
This whole business just we're coming in late. I have not been liking it, not really.
well, it's important this one day. Let me see. Let's see if that.
Yep.
Where are your offices?
Downstairs.
Oh.
Wait.
Ashby, and on behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking.
Somebody has their audio on their computer on because I can hear the feedback.
I'm Blake.
I don't know. I don't have. My. No, I know.
Oh, it could be me. Oh, speaker. It could be me.
Hit mute. And turn your speaker, your volume down.
It was me. It was me.
I'll try again. Good morning.
Apologies.
I'm still Jeff Ashby, and on behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking that each of you who may have an electronic device, cell phones, etc., to ensure that they are silenced. Now, for those of you online, that means stay muted until you're required to speak. We have additional agendas, including this consent agenda, available physically here in the back of the room, and I know it's also been provided electronically to those of you online. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted period. The commission has voted on those cases, and they will not be considered further today. At this point, we will adopt this agenda and the consent agenda.
Commissioner, I'm sorry to interrupt you, but before you adopt the agenda, I would like you to address a request to withdraw, because if you grant that request, it would change the agenda.
Yes, thank you. Ed, please.
I move that we disallow the withdrawal, deny the request for withdrawal in PA 20-0365 Grant versus Brown bag.
Nope, I'm sorry, it's H 22-0120 AB.
Oh, I'm sorry,
Maine-
different note,
Yep.
H 22-0120 A and B. Yeah.
Maine versus Saco Falls.
So the motion is to deny withdrawal in that case.
Do we have a second?
Second that.
So commissioners, first of all, is there any discussion? Second of all, because we are holding part of this meeting remotely, I still need to, for every single vote, we're required by our remote meeting protocols for me to ask each of you to signify your vote both orally and visually. I will go in order of seniority. So the motion is to deny the request for withdrawal. If you're in agreement, you will vote yes. Commissioner Ashby.
Yes.
Commissioner O'Brien. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Can I vote on this?
Have you seen it?
No.
Then you probably shouldn't.
Should, right, recuse.
So the vote is 3 in favor, 0 opposed, 1 abstain.
Great, thank you for that. Now, at this time, we'll adopt this agenda and the consent agenda. I'll entertain a motion.
I move we adopt the agenda and consent agenda.
Second,
It's been moved and seconded. Is there any discussion? Seeing none. If you are in agreement with adopting the minutes, I'm sorry, adopting the agenda and consent agenda, you'll say yes. Commissioner Ashby,
Yes.
Commissioner David,
yes,
Commissioner O'Brien,
Yes.
Commissioner Walker.
Yes.
Have you seen the agenda?
I did.
All right, excellent.
And we'll turn our attention to the minutes. For last meeting's minutes of September 2020, I'll entertain a motion to adopt them.
so moved,
Second.
It's been moved and seconded. Is there any discussion? Seeing none. If you're in favor of adopting the minutes from the September meeting, you'll say yes. Commissioner Ashby.
Yes.
Commissioner David.
yes,
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes, I have seen it.
Excellent.
Amy will take director's report, please.
Yes. So this is our first in-person meeting with commissioners present in almost 3 years. And as you can see, we're a little rusty, but we are getting it together. I can tell you, so that traditionally the executive director gives a monthly report on the goings on of the commission internally. You have a personnel report from me that shows that it was nice while we were fully staffed, but that is over. We had one investigator resign for personal reasons, and that position is posted. For compliance, you have some memos that purport to be from me, but are actually from Jane O'Reilly. And they are the status of reasonable grounds cases in which you all found reasonable grounds believe discrimination occurred. And what that shows is that we had 1 successful conciliation, we had 1 unsuccessful conciliation, and there are 5 cases in active that we're working on conciliation right now. And related to that, I'm going to ask that you approve a conciliation agreement in the 1 successful conciliation, PA 20-0365 Grant versus Brown Bag, meeting Sahara Club. You have the agreement before you with public interest remedies. So at this time, I would ask that you to approve that.
that's the one I tried to.
I know.
I tried to make a
Withdraw.
I move, we approve the conciliation agreement in PA 20-0365, Grant versus Brown Bag.
Is there a second?
Second.
So it's been moved and seconded. Is there any discussion?
I read through it and it seems as though the public interest is being fully satisfied by particularly by the monitoring and the ongoing monitoring of the compliance, as well as the notices and training and such. So it's educational to read that those requirements.
Amy and perhaps Barbara, is this when I've done this so many times, I think I know the answer to this question. Are these conciliation agreements the entire agreement, or do we only get the public remedy provision of the agreement? My recollection is that when there's a private settlement, there's some reference at least to a private settlement, maybe not to an amount of compensation if there is such compensation, but there's at least some reference to it. Is that going to always be the case, that we'll get at least some reference to a private settlement?
If there is a private settlement, it will be referenced
All right.
in our agreement.
Okay.
Any other discussion? Seeing none. If you're in agreement, I forgot that I had to do a thing. So if you're in agreement with approving the conciliation agreement in PA 20-0365, you will say yes orally and visually. Commissioner Ashby.
Yes.
Commissioner David.
Yes,
Commissioner O'Brien.
Yes.
Commissioner Walker. Okay. Next, we have investigation. I believe you have reports, but I'm not 100% sure, that show that, so for both September and October, we're reporting on these. In September, we received 44 new complaints. In October, I think we received 39, but I'm not sure that data set was updated in our reporting tool. Administrative dismissals. In September, I dismissed 8. In October, I dismissed 19. Predetermination settlements, so cases that settled before there was any investigators report. In September, there were 17 of them with benefits of $501,000 or thereabouts to complainants. In October, there were 27 with benefits of just shy of $600,000 to complaints. And then quarterly reports, and if you don't have reports from us, I want to apologize. Our reporting tool has changed since the EOC has changed its system, so they're not completely up to par just yet, the EOC system, so we're still working. And every quarter, I give you some quarterly reports that talk about cases pending, and I think you do have a report there that shows that in the second quarter, there were 660 cases pending. The average case age, which is pending charges, was 332 days, which is, I think, an improvement, but it's been so long since I looked at these reports, I can't even say. You have a training and education report that shows that commission staff either attended or presented at 13 events in the previous quarter. And there is a finance report, or will be. There is a finance report.
They have all the reports.
From Melody. Excellent. And we're happy to answer questions about any of those. And litigation, I would ask that we'll have a quarterly litigation report, but I would ask that we take those and your monthly litigation report, take those after executive session.
I'm looking at the first one, the commission meeting summary that has the.
Oh, you do have that.
Yeah, we have that.
Yeah.
My question is, what are those amounts of money refer to? Which types of cases? This is 501,500. This is paid.
Amounts to complainants.
Yeah.
So that's,
in which cases?
that only applies to the star there. It says withdrawal with benefits or settlement.
Okay, so it's only those
Yep,
cases
only those. Yep,
that are withdrawals, and so that includes private.
Yep.
Settlements.
yep.
They withdrew and they told you what the settlement was.
They may not have wanted to, but they did.
Well, is that required?
It will be soon, but it is highly encouraged.
Okay.
Julie.
I have a question. First of all, this is very strange because I did see the financial summary. Now I'm going to it. It says it can't be displayed. So I believe I saw in there that you had already submitted a budget to the legislature.
We have, yep.
And
We submitted it to the Bureau of Human Resources,
Okay,
to DAPS. They have not finalized what's going to the governor and the legislature.
okay, so they have the final say. I mean, not the final say, but
Yes.
they can.
Yes, they can.
Okay. And do they?
They do.
Okay.
Until we get to the committee,
What?
until we get to the committee for the governors.
Yes,
Yeah.
so the Department of Administrative and Financial Services, DAPS, has control over what goes in the budget in consultation with the governor.
Okay, yeah.
And if something that we have requested doesn't end up in the biennial budget proposal, we can ask for it from the
Okay,
Judiciary Committee to be inserted
Yeah,
and then go before appropriations.
okay. Thank you.
That is all I have, I think. And I don't really have any new business. I do have some statistics, but we've been delayed in getting our annual reports together for FY 21 and 22, but we finally have access to the data that will let us do that. So we'll be getting that together shortly. And actually, since you, I believe, Jeff, are the acting chair, it will be your name that signs the cover letter. So hopefully, before you leave here today, I can get a signature from you that we can then take a picture of.
Oh, dear.
And then copy and paste, and you will get to look at it before we submit.
Okay.
Yeah.
Maybe if I slide the chair the next time.
Yeah, that'll work. In our office, we throw a football. So that is all I have for the director's report.
Great.
New business.
Thank you. I mean, I think we're at 8:45 now, so we
Yep.
can proceed. All right, folks, the remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium, or if you're online, the virtual podium, to provide the most relevant arguments to the case. Time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only one relevant factual errors. 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask questions. I will ask that each of you introduce yourself as you come to the podium. Thank you. The first case on our agenda today is E20-0402, Daniel Darling versus Uber Technologies. Forgive me for a moment. I'll bring that case up. That's a no reasonable grounds case, and so as a result, we should hear from the complainant or the complainant's representative first.
Yes. And they are here, Mr. Darling and his attorney, Mr. Hepler. Do you want to unmute Mr. Hepler? Maybe I can unmute you. Maybe you can unmute yourself. This is hybrid is new for us. So there we go.
So I can't read the names.
That's
Darling,
Bruce
to the
Hepler. Mr. Darling is to his left on our screen.
Uh-huh.
And Mr. Hepler, we just unmuted.
Right.
And there he is, smiling and nodding. And below is Ellen Lemire for Uber. And the investigator, look at that, you got everybody up there. Way to go, Chelsea. Okay, Mr. Hepler, I'm gonna try to find, I forgot that I'm timing.
Good morning.
Good morning, so you will have 10 minutes. You may proceed.
I appreciate that. So I'm the attorney for Danny Darling, and Danny was an Uber driver, and was an Uber driver for many years. And while at the beginning of the pandemic, the vast majority of Uber drivers stopped driving, Danny was one of the very few who continued. It was his full-time occupation, and Danny was highly rated. Perhaps the highest rated driver in Portland, or at least among the top echelon of those riders. He got much praise from Uber for being so good, and then for continuing on through the pandemic. He needed to get special dispensation essentially from the state to be able to continue driving during the pandemic. And one of the things that's not really laid out very well, in my opinion, in the report, is that Uber had difficulties and was slow to react during the pandemic. Our governor issued several executive orders, and Uber flatly violated them. One of the executive orders was from March 31st, where Governor Mills said that you may not have more than one rider. Uber's been very admitted that their guidelines were that there could not be more than 3 riders, and so Uber continued to send rides to their drivers that were flatly in violation of state law. In addition, there's an executive order regarding face coverings that was from April 29th, and Uber was very slow to react to that as well. It caused a lot of friction, a lot of concern, a lot of anxiety, a lot of difficulties for drivers like Danny. And then there's also some OSHA regulations as well that Uber was flaunting. So Danny wrote a Facebook post on June 18th, 2020, where he called out Uber's CEO for their unsafe practices, for the real failure to comply with the law, their failure to protect the safety of the riders. Danny was terminated 9 days later. The investigative report finds that there was a prima facie case that we made out under the Whistleblower Act. Of course, we don't dispute that at all, that he did engage in activity that's protected by the Act, and then he was subject to an adverse employment action just 9 days later. The statement that there can be the third element is that there has to be a causal link between the two things. And that can be shown through proximity in time. Certainly with just 9 days in between, we showed that proximity in time. The other way you can do it is to get testimony from the Uber employees who did the termination. We were not able to do that. Uber flatly refused to identify any of the people who were involved in the decision. There was repeated requests from the investigator asking Uber to do that. Uber flatly refused. And then when we had the hearing on in July 28th, I believe it was, Uber did not produce any of those people for testimony. There's a bunch of odd things that have kind of happened in this case that I think also happened to really show why we think there is a causal connection, not just the 9 days, but why there is a causal connection here. One of those things was that Danny got heaps and heaps of praise and kudos from Uber within a month of being terminated. You would think it would be just the opposite. You would think that if he was on the brink of being terminated for complaints, that they would be telling him, hey, listen, you're getting a lot of complaints, look out here. No, that wasn't what the case was. 4 different times within a month of being terminated, they told him what a good job he was doing, and they were saying that he had excellent feedback from the passengers, which is the exact reason that he ended up being terminated for. Another thing that's odd here is that Uber gave inconsistent reasons for why they terminated Danny, which is kind of hard to understand, hard to explain. They said that he was twice, they told him that he was being terminated for engaging in fraudulent activity. They've since backed off from that. Why they got that wrong, why they were saying that twice, telling us a final decision that he was being terminated for fraudulent activities, we still don't know. A third odd thing was that we do have some of Uber's internal records, and they made a lot of odd comments. They were commenting on his Facebook post. Why are they commenting on his Facebook post in making these decisions if it wasn't a reason for it? We don't know that. There was also another odd comment where they said, unfortunately, 5 of 7 incidents were pre-COVID. Why is it unfortunate? We don't understand that. It doesn't make sense. Why are the facts fortunate or unfortunate? It looks like they're trying to make a case out against him. Other comments that were in the records were redacted. So we're not able to do anything here. Certainly another odd thing here is that Uber's obviously hiding things. They refused to produce the people that were involved in the decision. They refused to identify those people that were involved in the decision. That seems awful odd. If everything is above board here, why aren't they producing the people that made this decision? Another odd thing here is that Danny did over 7,000 rides. He got 7 complaints. It's a very, very, very low rate of complaints for Uber. Yet the majority of their riders have a much higher rate of complaints. Yet they terminated Danny. It seems very, very odd. And so, although we made this prima facie case, the investigators' report states that they overcame the presumption on the basis of the testimony of Corey Frivigel. Now, Corey Frivigel.
Actually, sir, if I could interrupt you, I'm just sorry. Can you please not use the names of any third parties? We gave them a pseudonym in our report. The Maine Human Rights Act makes the names of third parties confidential.
I'm not sure why he was a third party. He was the Uber representative.
Oh, I'm sorry. They were one of the attorneys?
No, he was, I mean, I kind of think he was a third party because he didn't have anything useful to add, but he was the head of platform safety.
Sir, any witness, anyone who's not a named party or a lawyer for this case, can't use their name.
I'm sorry. They use their head of platform safety. I won't use his name. I apologize. I didn't realize that rule. As in lieu of having anyone with personal information about this, they had him. He admitted that he was not involved in the decision to terminate Danny. I asked him who was involved in the decision to terminate Danny. He did not know. So not only was he not involved in it, he hadn't even spoken to anyone who was involved in it, did not know who was involved in that decision, yet it was his testimony that was used to rebut the prima facie case here. And he said that the reason for Danny's termination was limited to these 7 incidents, which is really just 6 incidents. But he said it was not for fraudulent activity, and it was not for comments that Danny made to Uber personnel. He was clear on that, but we just have a real difficulty having the prima facie case being overcome by someone without any personal knowledge of the incident, especially here where Uber was just flaunting the rules of the Maine Human Rights Commission, where Uber was refusing to produce witnesses with actual personal knowledge. The documents show any number of people here. Uber has not even identified them. They're only identified by their first names. I realize I'm not allowed to say those names right now, but there's a number of these 5 different people, which I believe are in our submissions, that appear to have been involved in the decision. Uber didn't produce any of them for testimony. Instead, they produced someone. It's really pretty impossible to ask him any questions because he wasn't involved in the decision. He really doesn't have any personal knowledge. Certainly, if this was in court, this was next door in Superior Court, he wouldn't be allowed to testify. And so it's pretty bothersome to us then that he was allowed to rebut this presumption of there being a causative link between Danny's protected activity and his termination from Uber. If there's no questions, I reserve the remainder of my time for rebuttal. But that's basically what we're here about here today.
Thank you, Mr. Hepler. I'm going to see if commissioners have any questions. Any commissioners with questions? If so, I'll take them in order of seniority. I see Commissioner O'Brien and then Commissioner David. Sorry, Commissioner David.
Do we have the Facebook post in the record?
Yes.
Okay. What does it say?
Say it one more time.
What does it say?
It said that the it's long. It rambles a little bit. He does accuse the CEO of killing Uber drivers. He's very upset. Uber was taking a very long time to react to the pandemic. Uber wasn't complying with the law. Danny was obviously very upset. He said that he was going to report them to OSHA as well for the violations of that. But it's in our submission. It's any number of times it's in there. It's in there as Exhibit D to our February 1 letter. It's in there on page 7 of that as well.
So what's the date of that Facebook post?
June 18th, 2020.
Okay. You don't address any of the 3, 6, 7 itemized complaints that the investigator listed against complainant.
Well, one of them Uber acknowledged wasn't really an incident because it had to do with sexual touching, and the Uber witness stated that if Uber had found a violation there, they would have terminated him immediately. So it's apparent that Uber did not believe that that allegation. So it really brings it down from 7 to 6. We've addressed them all in our submissions. Many of them seem old. They seem stale. It seems odd that these weren't being brought up. Uber admits that they don't really identify to Danny. They don't tell him because of the concerns of who they are. They don't necessarily tell him exactly who the person is. They'll just say that, hey, there's been a complaint. So he has a hard time of really trying to defend himself against those. Like, one of them was, a woman throws up in his car, and Danny was obviously upset and had her get out of the car, and she then filed a complaint against Danny for that. It's kind of hard to see how that's on Danny when she threw up in his car, but so in any event.
You didn't just say to me, did you, that he doesn't know when there's a complaint been made? He's notified of the complaint, is he not?
Yes, but he's not notified. It's done in very generic. Yes, he is notified. I believe in each of the times, but it's in a very generic fashion because they don't want to tell him exactly which one it was. And then Uber, their witness stated that Uber doesn't come to a conclusion with any of them as to whether it did or did not happen. So it was just that there are complaints, not that there are valid complaints as to the reason for him being terminated. So they don't make a determination of whether Danny did something inappropriate in each one of those. Although there was the one that they essentially admitted, they determined that he did not do anything inappropriate, because if the allegation were true, he would have been immediately terminated.
And my last question is about his comments to the management, the direct insults to management. Can you address that?
Danny got triggered. Danny said some things that he shouldn't have done, but you know, the Uber witness said he was not terminated for that. So we'll take him at it. We'll take him at that at value. So it really is a bit of a red herring to get into that, in as much as he was not terminated, you know, for that. So we'll take that. But in addition to that, you know, the Exhibit C to our initial submission, there are hundreds of writers who say that Danny, who praise Danny and say, you know, what a great conversationalist he was, how awesome he was, how terrific, you know, he was as a driver, and kind to them. So, I mean, I hope you see that, you know, Danny in general in his normal state is absolutely phenomenal with the riders.
Thank you.
Commissioner Ryan?
Yes, could you explain that, something that he was told that his account was flagged as a duplicate account connected to fraudulent activity, and I have no idea what's happening. Could you explain that, please?
Yeah, it really concerns us. No, we'd love to have you ask that question of Uber. We don't know. That was said. Uber then backed off of that, and their witness said that he, although they twice told him that he was being terminated for that, and that that the decision was final on that, they ended up backing away from that. That's very concerning to us, that they went and said that. They have said that no, he did not do he did not have a duplicate account. He did not do anything that was fraudulent. They've been very clear on that, but it really makes us concerned. Looks like they were fishing for a reason after the Facebook post to terminate him. And that was one of the things that they came up with, but then realized that it didn't make any sense. They also told them that they were going to have a special investigative team within 3 to 5 business days address all this, and then Uber never did that. It's really kind of odd that happened. They said this issue needs to be addressed by a specialized team. They'll reach out to you within 3 to 5 business days. Uber didn't do it.
Thanks. Any other commissioner questions? Seeing.
I have no. This is a whistleblower complaint, right?
Yes.
Okay, and you're saying that that's in the form of a Facebook post on whose Facebook page?
Uber's.
And it doesn't have to be to a government agency. He doesn't have to report to somebody that is an unsafe working condition or whatever the language is.
He says that he's going to go to OSHA within that post.
But he doesn't.
He said, I'm contacting OSHA to let them know that you are asking drivers to wear a mask. I'm not sure if he ever did actually make the complaint to OSHA. He told them that he had told OSHA. Whether he actually did or not, I am not sure.
Okay.
Commissioner David, just
Yes.
to clarify the point, the Whistleblower Protection Act requires a report to the employer.
Okay, all right. Thank you.
Any other questions for Mr. Hessler? Okay, then we will turn to respondent. Mr. Hessler, you'll have just under a minute left when we come back to you.
Thank you.
And Ms. Lemire, I'm not sure I'm pronouncing that right.
You are. Thank you. Good morning. Ellen Lemire on behalf of Uber Technologies. There are no reasonable grounds to believe that Uber retaliated against Mr. Darling, and the investigator's report should be adopted and Mr. Darling's complaint dismissed. Now, while Uber disagrees with the investigator's finding that Mr. Darling was an employee of Uber, and also with the finding that Mr. Darling has made out a prima facie case of retaliation, Uber does agree that it deactivated Mr. Darling's access to the Uber app because of the excessive number of rider complaints it received about him. There's no dispute that Mr. Darling received many rider complaints about his alleged language and his behavior toward riders. In fact, there are documents that the commission has reviewed and that the investigator has that show each of the rider complaints. And there's documents that show that Mr. Darling was made aware of each of those complaints and that he was cautioned that additional complaints could lead to his account being deactivated. Mr. Darling's position, which was not part of my brother's presentation this morning, but Mr. Darling's position is that each of those rider complaints is fake, is some kind of pretext so that Uber could deactivate his account. First, and the investigator made this point in his report, each rider complaint originated from a different rider, a member of the public in Portland who was using the Uber app to get a ride. So making the idea, and that makes the idea that Uber somehow contrived to get these riders to make false complaints against Mr. Darling, that's very far-fetched. And then Mr. Darling claims that the riders are each lying about each of their interactions with him. So he claims that what the riders were complaining about, namely the vulgar, profane language, that just never happened. That was his position during the fact-finding conference and in his submissions before the commission. Unfortunately, each of the rider complaints alleges that Mr. Darling used exactly the kind of profane, angry, insulting, and inappropriate language that we know, and we have proof that he regularly used in written exchanges with Uber's support team and during recorded phone calls with Uber's support team. The investigator's report correctly identifies the issue here. In what company would it be okay for a worker to scream at customers, to call customers the B word, the C word, to tell them to F off and to go F yourself? That's what Mr. Darling is asking the commission to do. He thinks he should be able to act like that in a workplace without recourse. And that's just ridiculous. Uber gave Mr. Darling chance after chance, and the abusive, racist, profane, and frankly terrible language continued. So Uber deactivated his account. Now, Mr. Darling has asked the commission, has asked you to reject the investigator's report for several reasons. First, that Uber was slow to react to the COVID-19 safety precautions and to the pandemic itself. That is simply not true. In early 2020, Uber took actions to address the public health threat. They created a global steering committee. They tracked the best available objective evidence from the CDC and other resources. And we have to remember that back in March 2020, April 2020, we didn't know about masking. This situation with the coronavirus was evolving. And it was not until May 20th, 2020, that OSHA issued an alert for rideshare vehicles that recommended masking on top of the other safety mitigation steps like opening windows and limiting riders. And it was just days after that May 14th OSHA alert on May 18th, 2020, that Uber launched its door-to-door safety standard, including a series of new safety features. And I'll defer to my our submissions for the rest of that, but the idea that Uber was slow to respond to the pandemic is just not true. Next, Mr. Hepler throughout this hearing has claimed that Uber refused to identify the person who made the decision to deactivate Mr. Darling's account. That is false. Uber identified the person by name in its final submission to the commission. Mr. Hepler has that person's name. Regardless, the witness for Uber, the head of global platform safety, testified about the more important matter, the more relevant matter, which is what process does Uber follow when it decides to deactivate a rider account? And Uber's witness, the head of platform safety, testified in great detail about the safety specialist who was assigned after Mr. Darling's account was flagged, after a number of complaints were received. A safety specialist was assigned, and that person made the decision to deactivate Mr. Darling's access to the app. That person had access to see all of Mr. Darling's in-app conversations with the Uber support team. That safety specialist reviewed each rider complaint to make sure that none of the riders who complained had a history of making false or fraudulent complaints, and none of them did. And to Mr. Hepler's argument that the profane, racist, insulting, terrible language that Mr. Darling used with the Uber in-app support team, even if the safety specialist did not base his decision to deactivate Mr. Darling's access on all of that, that inappropriate language tells you exactly what riders who complained about the same profane language were experiencing from Mr. Darling. So it goes to another purpose. The argument that Mr. Darling had 7,798 rides that he did a good job on. First of all, asking the commission to sit as a super personnel department and make a business decision, make a business judgment about when and how many complaints it took Uber to deactivate Mr. Darling's account. The commission cannot do that. But I ask you to think about it this way. If somebody worked for a company for 7,798 hours, or if each one of Mr. Darling's 7,798 rides, let's say each one of those lasted 30 minutes, which I think is generous, that would work out to about 1.3 years of work. And if an employee racked up the number and type of customer complaints that we have against Mr. Darling in just 1.3 years of employment, would you expect the company to keep that employee around? I think that answer is no. Uber has asserted legitimate, non-discriminatory explanations for the alleged adverse action, namely that Mr. Darling had accumulated an excessive number of those rider complaints, and the company took into account each one of those, and his history of verbal and written abuse toward the Uber support team. Mr. Darling has not met his burden of showing that the real reason for the alleged adverse action was his Facebook post. And so I'm asking the commission to adopt the investigator's report and dismiss Mr. Darling's complaint.
Thank you. Thank you, Ms. Lear. At this time, I'll see if commissioners have any questions. Any commissioners with questions? Commissioner David?
Did I understand you to say that he's cautioned or notified after each complaint?
Yes.
Okay, how is that done?
It's done through I'm sorry.
If it's in the record.
It is. It is, and it's I believe it's exhibit A to our August 4th submission after the fact-finding conference. Each of those complaints are sent to Mr. Darling as in-app messages, written messages. We know he received them because his reaction to them often resulted in these profane rants toward the Uber support team members.
And did the company respond to his complaints about unsafe working conditions. It's a little bit unclear to me exactly what his report is. His report is that the company's not enforcing the governor's mandate, or exactly what is the issue? I suppose I have to ask Mr. Heckler.
Right. I mean, I agree with you that, I mean, I'm sort of unclear about what exactly his complaint was. However, I don't think that this is not in the record, I don't think, but I don't think Uber ever responded to his Facebook post.
Okay, thank you.
Any other questions for Ms. Lemire? Seeing none, Ms. Lemire, you'll have about 45 seconds left when we come back to you.
Thank you.
Mr. Hepler, you have about 45 seconds. But you have to unmute first. There you go.
There were executive orders limiting the riders to one. Uber's policy was 3 riders were allowed. There was executive policies on the face mask. It took Uber months after that. To act like that Uber was quick on this is absolutely false. Uber was super slow. Let's not forget that this was just 7 complaints here out of 7,798 rides. It was an extraordinary low rate of complaints. People make complaints so they can get a free ride. People make complaints for other reasons here. In comparison to other riders who were not fired, his rate of complaints was very low. Something else happened here, and that was his complaint that Uber was violating Maine law. Uber was violating Maine law.
Mr. Hepler, that's your time. Thank you. Any follow-up, Commissioner David?
Yeah, his complaint was that Uber was not creating a regulation in accordance with Maine law for him to enforce about face masks. Exactly what is his whistleblower complaint?
Uber wasn't protecting its drivers. Uber wasn't complying with Maine law. They weren't complying with Maine law.
How?
Maine law was that you weren't allowed to have more than 1 rider in the car at a time. Uber's policy was 3. They were still sending him rides with 2 or 3 riders in them to complete the ride. But Danny was violating Maine law. In addition, Maine law from the executive order was that everyone needed to have face masks. They were Uber didn't make that a policy for a couple months, and even when they did, they were very lax in that. It wasn't. That was what the last complaint happened in this case, was because it was one of these people that didn't want to wear a mask. Danny refused them, and the person made a complaint, and so then they fired him. I mean, it's unbelievable. Uber was so slow on this. Uber wasn't paying attention to Maine law. They didn't even have a Maine lawyer on this. They still don't have a Maine lawyer on this. They still don't have someone licensed in the Maine bar representing them on this.
Anything else, Commissioner? Yeah. Any other questions for Mr. Hepler? Seeing none, thank you, Mr. Hepler. Ms. Lemire, you have about 45 seconds left.
Thank you. Nothing further. I think Mr. Darling's statements and conduct speaks for itself.
Thank you. Any questions from commissioners for Ms. Lemire? Seeing none. Thank you, Ms. Lemire. So we've heard from the parties, and now we would turn to the investigator, Mr. Beauchesne.
Good morning, commissioners. Just to touch on a few particular facts in this case, I would say that aside from the close proximity of the Facebook post to the deactivation, there was little in the record to support that was in fact the triggering factor for the adverse employment action in this case. I certainly did make it more difficult with the inability to nail down who the actual decision maker was until pretty late in the process. We had a witness at the conference that testified generally as to what the process was as far as the accumulation of particular complaints And while there was not a magic number per se, apparently once it gets beyond 6, 7, that there is a process in place whereby the individual complaints are reviewed and somebody makes a determination as to whether or not that person should continue as an Uber driver. So in this case, that's how we, I guess, got to how the decision was made. But there wasn't a particular individual where I could ask how much of it was the profane language towards customers, how much was the abrasiveness towards staff, and what else was involved here. And certainly the fact that complainant was given seemingly inconsistent explanations. There were emails that were sent or messages that were sent that hinted towards either a fraudulent account or a duplicate accounts. And again, at the conference itself, the individual that was present did not say that either one of those were a factor in the ultimate decision, leaning entirely upon the I guess the nature and the number of the particular complaints in this case. I think for me as well, one of the issues was complainant's credibility. He testified at the conference that at no time during any ride over his years of driving did he ever use profanity towards a rider. And again, in this particular case, there was no shortage of hard evidence showing that he used very abrasive and discriminatory language towards other members of staff. So for him to claim that at no time did he ever use profanity towards a rider just wasn't found to be credible. In the 6 or 7 cases that were referenced, again, as noted by Respondents Counsel, we're talking not only telling someone to go to hell, but certainly much stronger, more profane, and more sexually based language. It was difficult for me to conclude that he would have never used that language towards a customer, yet had no reluctance whatsoever to tell its company to F off repeatedly in dozens of messages, in addition to other offensive language. So again, in this particular case, it really came down to who to believe during these customer complaints. And again, while it's certainly possible that some of these people filed complaints against them because they were trying to get a free ride, the idea that all 6 or 7 complaints were consistent in how they reported how he was towards them, both with respect to his behavior and his language, it's difficult to believe that each and every one of those complaints was fictitious or overstated simply to get out of a ride. I'm here to answer any questions you might have.
Thank you, Bob. Any questions from Commissioner O'Brien?
I guess I'm going back to the question I asked before. Could you explain what is a fraudulent duplicate account? What does that mean?
Certainly, and there was really no way to follow up on that particular point. Again, it was mentioned in a message, but there was nobody there. In reviewing the telephone messages and some of the other information that was produced by the parties, and again, pure conjecture on my part, but he did make threats as far as I'm going to become a Lyft driver. This is the last time I'm ever doing an Uber ride. So I don't know whether or not that was the veiled reference to what the other account was. We were really never able to pin that down. However, the witness that was produced at the conference indicated since he was responsible for drafting this deactivation policy, or one of the individuals, was that it was simply part of the process, that after a certain number of complaints were received, that it was sent to a review panel who made the ultimate decision about whether or not to continue the driver to continue working for the company or not. And that's what we were told in this case, was that it was the accumulation of these similar based complaints that were made against him.
Any other questions from commissioners for the investigator? Seeing none. Thank you, Bob. So commissioners, we've heard from the parties and the investigator. At this point, we'll be looking for a motion.
I'll move that we find there's no reasonable grounds to believe that Uber retaliated against a complainant for engaging in WPA activity, and the complaint should be dismissed.
Second.
So it's been moved and seconded to find no reasonable grounds to believe that unlawful whistleblower protection act retaliation occurred. Is there any discussion?
It just seems to me that the nature of the complaints and the number of them and the consistency of them, it does raise a credibility issue that he denies them all completely. But they are sufficient, along with the confrontation and the language used against directly against management, to suggest that this is not a pretext for whatever the Facebook post said, which I don't think I've seen, but it's enough to convince me that there's sufficient grounds. And I'm not going to second guess, exactly how many complaints there have to be or not be. These are serious and a reasonable basis for ending the association with them.
Any other discussion? Seeing none, the motion is to find no reasonable grounds for whistleblower protection act retaliation. If you say yes, you are in agreement with that. Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner O'Brien. Yes. Commissioner Walker. So the finding is no reasonable grounds. And we thank parties and council for participating. The commission will send all of you a letter confirming that. Thank you so much. And with that, I'm going to go I know respondent's attorney is here in person. And I know Mr. Lee in the next case. Where did we put them? There's a room right there, 324, and there's both Mr. Langsdorff and Mr. Hodgkins. The second case, yeah.
So next is E20-0447, Zachary Mayer versus the town of Mechanic Falls. As you heard, we're
Try to get your iPad on.
getting the parties. This is a no reasonable grounds case, so we'll hear from the complainant or complainant's counsel.
And before we start, I just want to get respondent's attorney and respondent are here in person.
It's out there, his client has run to the restroom, so it'll be a sec.
Thank you for your patience, Mr. Lee.
No problem.
Hey there. You guys just want to have a seat right there. We're going to hear from complainant's counsel first. And Mr. Lee, you may proceed.
Good morning, commissioners. I apologize for where I am today. I'm at home because my office carpet is getting torn up today, so I hope it's not distracting. So I'm attorney for Zachary Marr, and this case is somewhat factually and procedurally historically complicated, but this portion of the case is really quite relatively simple. It's a straightforward Maine Human Rights Commission complaint retaliation case. And so that requires this commission to ask a pretty simple, straightforward question, and that is whether, as a result of my client filing a Maine Human Rights Commission complaint, did the town take materially adverse action? We think the answer to that question is also quite simple, and the answer is yes. Frankly, because this is a public municipal employer, you have in recordings of a hearing statements made by two counselors that the reason that they took actions against my client
this
was
commission just doesn't
because,
care. That's my opinion.
I'm sorry, can we pause my time?
Yes, I don't know where that's coming from.
This Dan is unmuted. I'm muted.
Oh, he's muted now.
Okay, good.
Sorry about that. Someone unmuted themselves.
Okay.
Mr. Lee.
No problem. So we have quite clearly in the record at public meetings, two of the counselors who had taken material adverse actions, admitting that the reason that they were taking material adverse actions was because Mr. Marr had what they called filed a lawsuit against the town. That was clarified at the fact-finding conference that what they meant by, quote, filing a lawsuit was indeed the Maine Human Rights Commission that he had complaint that he had filed. So in terms of causation, there's very little question here. You have direct evidence from the employer that the reason they were taking materially adverse actions was because of the filing of a Maine Human Rights Commission complaint. We think the investigator's report is flawed in two respects, and they're somewhat related to one another. One, we think it uses the wrong legal interpretation. We think it uses an adverse employment action analysis rather than a materially adverse action analysis. And I'll get into the details of that, but the implication of that for this case is that the second problem that we find with the investigator's report, and that it sort of minimizes the actions that were taken against my client because they weren't adverse employment actions. Specifically, the action of not speaking as counselors to a town manager. That makes it incredibly difficult for one to do their job. So I told you I'd get to the gist of the legal argument here. There's a big difference between materially adverse action and adverse employment actions. And the US Supreme Court has talked about this, and it distinguishes between anti-retaliation statutes and anti-discrimination statutes. And it says that while non-discriminatory provisions of anti-discrimination statutes seeks to prevent adverse employment action based on who someone is, right? Whether they're someone who's of an advanced age, or if they're a racial minority or a woman, that's anti-discrimination statutes. They say that when a statutory anti-retaliation provision, on the other hand, seeks to prevent harm to individuals based on what they do, i.e. their conduct. Therefore, anti-retaliation provisions, unlike the substantive provisions, are not limited to discriminatory actions that affect the terms and conditions of employment. So it's a wider scope of actions that are scooped in when you have an anti-retaliation provision. That means, and this is actually quoted in the investigator's report, despite the fact that it doesn't do this in analysis, the term materially adverse action covers actions that are harmful to the point that they would dissuade a reasonable person from making or supporting a charge of discrimination. That's why it's uniquely this commission's ken to enforce the anti-retaliation provisions, because you're having a situation where a person is less likely to make a legitimate complaint about discrimination if they will be retaliated against for doing so. And that doesn't have to be with respect to terms of their employment. The court goes on to say, for purposes of anti-retaliation provisions, my client in this case, or any plaintiff making these claims, don't have to show material terms and conditions of employment. Instead, quote, the scope of the anti-retaliation provision extends beyond workplace-related or employment-related retaliatory acts or harms. All my client needs to do is show that a reasonable employee might have found that the challenged action materially adverse, which is the context means it might have dissuaded a reasonable worker from making or supporting a charge of discrimination. We think that's clear here, which brings us to sort of the second problem in the investigator's report. And that is, it minimizes this idea that the materially adverse action was simply not talking to the town manager. And so I admit that there's some need to understand how a municipal employer context works in order to understand this issue, but it's incredibly important that the chain of command exists such that a counselor speaks to a town manager who manages the employees of the town. The town charter provides that the town manager is the one who carries out personnel policies, that they manage every staff member of the town. Otherwise, if you have city councilors or town councilors or boards of select people who are made up of 5 to 7 individuals, if those individuals are able to go and provide a directive to each staff member, then the staff member has ostensibly 8 different bosses. That's not a workable system for any town manager to live under. Now, that doesn't mean that a counselor can't go have a direct interaction with a staff member, but it's clear through the town manager. And if you have a city councilor, a town councilor who refuses to speak to the town manager about anything, much less the management of the town, then you don't have a possibility for the town manager to understand what directives a staff member will be receiving. So I would argue that that would rise to the level of an adverse employment action because it makes it impossible for a town manager to do his job. Nevertheless, I don't even have to prove that it's an adverse employment action. All I have to prove is that it's a materially adverse action. And because those actions were taken here with respect to Mr. Marr, it was an unworkable job. Now, this is not part of the record. He's no longer employed there. That's not relevant to necessarily your analysis, but it was an unworkable job for him to do at that point because he could not manage his staff without intervention by different town councilors who would not even speak to him. So I'm looking forward to answering your questions if you have any, and I appreciate your time.
Thank you, Mr. Lee. Any questions from commissioners? Commissioner Ashby.
Yes, hi. I'm so sorry, I
Mr.
forgot
Lee.
Mr. Lee. I can't.
No, it's very tiny right now.
I can't see very well, so I apologize. Mr. Lee, on the very top of page 3, the very bottom of page 2 of the investigator's report, there's a discussion at paragraph G about the complainant submitting a letter of resignation to the town. And in there, the complainant allegedly indicated that one of the reasons why was that council had allegedly made it clear to complainant they would not entertain another employment contract after his current term expired in June of 2022. What does the record say about that allegation? Is it the case that it's in the record that council for the town indicated to complainant they would not entertain another employment contract after 2022?
There's not record. It's not in the record, the communications themselves, because I believe that they took place orally. But there was discussion that he had with counselors, not these 2 counselors, because they wouldn't communicate with him, but other counselors that indicated to him that there was absolutely no chance that there would be, if that present council continued, a consideration to extend his contract.
Oh, forgive me then. So council there maybe is misspelled. It's council CIL, that he believed that the town council had allegedly made it clear.
Yes. Yeah, it's
not an
confusing.
attorney from the town. Well, regardless of whether it's council or council, if that's true, if that were a fact that were found by our investigator, isn't that an adverse employment action?
That they would refuse to consider an additional contract?
And for the town to tell him that that they're not going to rehire him after the expiration of this term?
Sure. I don't need to prove an adverse employment action, but I think that's another materially adverse action that was taken in this instance.
Well, my verbiage may have been wrong, but material adverse action, right?
Yep.
All right, thank you. I have no further questions.
Any other commissioner questions for Mr. Lee at this time? Mr. David?
Let me get back to where it was.
I'm sorry, I couldn't hear that.
No, I'm looking, a second.
You
Oh,
can't
okay.
hear because it's not speaking.
It's one of the challenges of a hybrid environment.
Well, yeah.
The investigator's report indicates that the retaliation, that the complainant alleges that the retaliation, this is on page 3, paragraph 5A, that the retaliation is 1, certain council members refusing to speak, 2, undermining his authority by speaking to his subordinates, 3, publicly questioning his honesty, and D, seeking to modify the length of his employment contract, and 4, questioning his residency. What of those are retaliations for what?
For filing a Maine Human Rights Commission complaint.
And what's the connection between those? How do you argue that that's
In a public meeting, the counselor said in discussion of the extension of his current contract and in discussions that were dealing with why they weren't talking to him, sorry, one of them said, so I would not go into his office and have a conversation and ask him what he does because I don't dare to. As I said, he was suing us and I was not in a position to go in to speak to him. That was clarified at the fact-finding conference. What she meant by suing him was filing a Maine Human Rights Commission complaint. Another counselor
dismissed and settled and he continued his employment, right?
Yes. And then he continued to have discriminatory actions taken by counselors who were not actually parties to the council at the time that initial settlement took place. Which is exactly the point, right? He settled the first action, right?
Right.
That action's done, meaning he's no longer, quote, suing the town. The council.
And then you're saying that an individual counselor saying, I don't want to talk to him alone because I don't trust him as to how to.
Because he filed a Human Rights Commission complaint against this. Yes. You have two counselors doing it because another counselor said, and that is one of the reasons I feel uncomfortable going into the office and talking to Zach because I am also afraid of more litigation. Again, clarified at the fact-finding conference, what she meant by more litigation was a Maine Human Rights Commission complaint. So you have two counselors saying, when Mr. Marr files a Human Rights Commission complaint, I'm not willing to work with him at his job. And then he files a Maine Human Rights Commission complaint, and they're further not willing to work with him at his job. And that's
Any other commissioner questions? Mr. Lee, this is the time for questions.
Sure.
Any other questions for Mr. Lee now? Seeing none, Mr. Lee, you'll have about a minute and a half when we come back to you.
Thank you.
At this time, we're turning to respondents who's here in person, respondent and their attorney.
Morning, commissioners, Amy, Barbara, Mr. Lee, and Bob. Thank you very much. My name is Steve Langsdorff, and I'm here on behalf of the town of Mechanic Falls. Town manager Vic Hodgson is here with me today. It's nice to hear in person. So this case is a case that I'm uniquely, perhaps not absolutely uniquely, but very well qualified to defend because it's a confluence of both employment law, which I've been defending cases here at the Human Rights Commission since 1986. I've also am the chair of the Municipal Law and Finance Group of Credit Clarity, and so I represent municipalities across the state, and we were hired in this case to be brought in to defend this employment case. We're the town attorney. So I have a particular expertise in charters and how charters work and the council manager form of government. I've been the Augusta city attorney for almost 25 years now. All of what we're talking about here today is in relationship to the charter from the town of Mechanic Falls, which is the charter itself is entitled Council Manager Charter of the town of Mechanic Falls. And so the way that the process works by law, as many of you probably do understand, is that charter is the constitution for any town, and it is critical that the town act in accordance with the process that's set forth in the charter very specifically. And the charter lays out exactly what it is that's required of the council, what the council's duties are, and what's required of the manager as well, and how interactions are supposed to work between the council and the manager. In this case, Mr. Mayor is trying to prove that there's retaliation that occurred here, which I do agree. It's the only thing we do agree on is the standard is a material adverse employment action, which is caused by the protected conduct. And no question that there was a case that had been going on and he had been reinstated and brought back into position. And so the adverse actions that were set forth, primarily some of the issues are very, very clearly not only not in violation of the charter or process of retaliation, but issues that basically councilors that were aware of, had to address if there were violations of the charter. The residency requirement is a perfectly reasonable, legitimate thing for councilors to bring up. That's in the charter. The length of the agreement, absolutely reasonable when the charter provides for a 3-year agreement and you have a council erroneously entered into a 4-year agreement. That's something very reasonable to be worked out. And in both of these cases, those issues were worked out without there being any adverse effect. The question and the issue that really is primarily being raised here is kind of off the record types of communications between the manager and councilors, and potentially between councilors and staff members. And that's all very well laid out, the process in the charter as well. There is no process whatsoever where councilor members are supposed to go in, have private meetings with the manager and talk about their thoughts. The way the councilor manager form of government works is a very strict delineation. The manager manages the staff and is fully 100% responsible for personnel decisions. That manager is managed at public meetings by the council. And there's a very specific process of how the councilors manage that process, similar to what you did here. We had an executive session that have required public meetings, and very much the same way. This is the way that a manager has to be, it's supposed to be handled under the law and under the charter. There's absolutely nothing in the charter which talks about councilors meeting privately with the manager to talk about issues. As a matter of fact, that's a kind of a thing that in some towns and some managers very much would like to have their councilors come in and speak to them individually and maybe share some thoughts with them as an informal type of process. And many of the towns that represent that would not be the case at all. The managers would resent that, and they would prefer to be allowed, not only would not be a materially adverse effect for them to not be talking to those councilors, but it is actually the way that they wish to do their job. They're responsible for management. And when issues come up, they bring those up to the body as a whole. And the body as a whole, the council, is what makes decisions. It's not in any way based on what happens in private meetings that these councilors were unwilling to enter into with the manager. Likewise, there was a suggestion that it was somehow improper for the councilors to be in any way having communications with staff members or getting information from that. In fact, the charter is quite specific on that point and does specifically state that the council may not manage the staff, but it has the right of inquiry. So the council of the charter itself is very clear that it is not improper for a councilor to be getting information from staff members, not managing them, not telling them what to do in any way, but getting information from them. In this particular situation, I think a point was very well brought up earlier about sort of the dangers of having these private conversations when there was some suggestion, well, is it in the record or not in the record that the council was somehow saying that they would not renew the contract after the 2022 timeframe, which, by the way, they never got to because he resigned, long in advance of that. And what Mr. Lee brought up was, well, I think there were conversations about this and that. But that's really not a part of the process, and it shouldn't be a part of the process. So we do not see in this case at all that there is any issue with any type of a materially adverse action that was caused by the fact that Mr. Mayor returned to employment. Obviously, it was a very difficult situation. He had already been terminated before he filed his first main Human Rights Commission complaint. So there's clearly issues and lack of trust and issues going on, in the workplace. I think all these counselors have said, and I think it's quite understandable, is that I don't want to be in a private room where I'm concerned that conversations can be misrepresented for whatever reason. I will do my business in public. There's nothing in the record that suggests that in any way there's something about this process which materially adversely affected Mr. Mayor from doing his job. He was able to manage his staff. He was able to present his budget and everything else that's in this very lengthy charter that he's responsible for. There's 7 or 8 pages of duties. There's not any indication that in any way was he prevented from doing any one of the duties that are set forth in the charter. And I think that would be what you would consider to be a materially adverse situation, not that these counselors, individual counselors, not acting as goal saying, we don't want to be in a private meeting. So this is someone who was returned to his position, didn't suffer any of what we would consider to be the recognizable types of adverse employment actions, same position, same pay, same responsibilities, and so forth. This really just uniquely turns on an interpretation of whether and how charters work. And I just, from my experience and from going through this record here, I don't see how this council or the town itself who's been sued here took any actions which would have had a materially adverse effect on Mr. Mayor's ability to do his job. I think that Mr. Beauchesne did his typical thorough job of investigating the matter and held a fact-finding conference. And I would ask that you defer to him. And I think that he did fine properly in this matter. So I'm available to answer any questions if you have them.
Thank you. Mr. Langsdorff, any questions for Mr. Langsdorff?
Mr. Langsdorff, I do want to follow up on this question I had asked earlier. Is there any evidence in the record that it had been represented to this complainant that arguably before he resigned, that he would not be rehired in 2023 or after 2022?
I didn't see that in the record.
And your adherence to the importance of the charter goes to that issue, right? Like if you ultimately weren't hired after 2022, this is a hypothetical, of course, but if he ultimately weren't, the town could argue that the town charter, of course, required that he be a resident. He wasn't a resident, correct?
Well, there is that requirement. They did ultimately decide to waive that requirement.
That's my question. The charter does permit waiver. Is that?
Yes, it does. Specifically allows waiver, and they did do that.
I think that I should probably ask this question of counsel for the complainant, but is it the case? I see that our investigator found that at the fact-finding conference, the complainant indicated that there really was no problem with not communicating with the councilors directly. He was happy to use email or telephone. Is that something that happened at the fact-finding conference?
I personally was not there, but I did see that in the record, and that also further confirms that the necessity for private in-person meetings is unnecessary, especially if there are other ways of communicating that information.
And similarly, at the same conference, it looks as though maybe it wasn't the same conference, but he indicated that there is no authority that prevents counselors from speaking to staff and department heads.
Yeah, that's what I said. From the charter, it talks about the right of inquiry as opposed to the right of management.
Thank you, Mr. Lang.
Okay, thank you very much.
Do you have any other questions from commissioners? Seeing none, thank you. You've got about a minute and a half. We'll come back to you. Mr. Lee, we are back to you. You have about a minute and a half.
Yeah, I don't know that our municipal resumes are exactly relevant to the commission's consideration of this, but I presently represent 3 towns, was in-house counsel for the city of Portland, and served 2 terms as a city councilor.
I'm going to encourage,
Nevertheless.
and I know you're saying exactly what Mr. Langsdorff did, and I should have stopped him. Oh, hello, Katie. I should have stopped both of you from sharing the other people you represent, because none of it is relevant in this case. So let me just say that to both of you.
Precisely. I think that there's sort of a failure to recognize sort of the collateral consequences of these 2 counselors' failure to communicate with my client. And one of them is both of these people said that they could not provide an evaluation of my client's job capabilities because they didn't have enough interactions with him because they were refusing to interact with him. So that was one of the implications of their failure to have those interactions with him. I 100% agree that there's an ability to inquire of employees, of staff members, but not an ability to manage. The delineation between those two, as anyone who has dealt with municipalities can tell you, is a difficult one. And it requires communication between the counselors who are having staff communications and the city manager who's in charge of managing. And so that delineation between inquiry and management is one that is precise, is much more difficult, rendered much more difficult when you have counselors who are disagreeing and unwilling to communicate with them. Two big issues that came up in their attempts to shorten his contract was the residency issue, and it was the issue with the contract being improperly entered into to begin with. Both of those were issues that Zach himself brought up and had been seeking waivers for.
Mr. Lee.
Yep.
Mr. Lee, I'm sorry to interrupt you, but that is your time, and I did tack on a few seconds for my interruption.
For the cat, yeah.
Yeah, no, but the cat I did not count against you at all. No, for my interrupting.
Sure.
Any questions from commissioners for Mr. Lee? Seeing none. Thank you, Mr. Lee. Mr. Langsdorf, you have about a minute and a half left.
I have nothing further. Thank you.
Okay, thank you. So then we turn back to Mr. Beauchamp.
Thank you, Commissioners and Amy. I guess for me, this really came down to a very nuanced point. The council members made specific statements that did reference the commission complaint in arguing why they did not want to have private conversations with the complainant. However, if you look closely at those statements, what they were really saying was the prior suit had been settled. And at that time, these discussions involved reworking complainant's contract that by everyone's accord was not in compliance with the charter because it was for too long of a period of time. And the email that complainant sent that predated those comments essentially said that I will view anything that I deem to be a negative change to my new contract, I'm going to view through a retaliatory lens. And it was really those comments that led the counselors to say, look, we got this other suit settled and now he's threatening to do it again. And that was precisely when those comments were made. It was in response to complainant and his counsel's claim that anything that they viewed negative in the new contract would be viewed as potential retaliation. And complainant's comments also pushed back on anybody seeking what he viewed to be micromanagement as to how he was progressing on various projects, indicating that anything that he felt was going to be, again, micromanaging what he was doing was going to be viewed as potential retaliation as well. So again, in this case, as I noted in the report, clearly having certain council members not speaking directly with the town manager was far from an ideal situation. But again, as was noted earlier, complainant was asked a specific question as to why the in-person needed to be in person, and he indicated clearly that email and telephone were fine for most communication, and these council members did have conversations with him at the public meeting. So there was nothing in the record that indicated to me that there was any right or obligation to have in-person meetings if these particular council members did not wish to do so. And the same was true with respect to contacting his staff. While certain town managers may very well like to have all communication go through them, there was nothing that was produced by complainant or respondent that indicated that there were any barriers on a council member from speaking with the department head directly if they wish to do so. So again, while it may have been a different management style that complainant preferred, I saw nothing that there was any type of an obligation or prohibition on council members speaking directly with his staff. So again, I think that the The reference to the commission complaint certainly concerned me at the front end because it almost appeared to be direct evidence. But in examining these statements themselves and the chronology, it was a response to his threat to bring potential future litigation and not necessarily his prior commission complaint that evoked those statements from the council members.
Thank you, Bob. Any commissioner questions for the investigator? Commissioner David?
Bob, where is that communication?
What communication?
The communication that he's agreeing to, the communication that he view any adverse action as retaliatory.
And as I say, there is an August 6th email, which is listed as Exhibit 1 and one of complainant submissions. I don't believe it's attached to the report itself. But again, in these emails, and granted, at this time, both sides understood that the prior contract was invalid because it didn't comply with the 3-year time limit. So both sides were attempting to get a new contract in place at that time. And it was during some of those exchanges where comments were made, and this is actually from a September email. I do not wish to be micromanaged, nor do I feel it is appropriate for individual council members to provide direction to my staff. And there was a prior email again speaking about what the new contract would look like, where again, he had indicated that anything that appeared to be retaliatory that was added into the new contract would be viewed through the lens of potential retaliation as a result of the prior commission complaint. And certainly he and his attorney had every right to negotiate the absolute best terms that they wanted to have. But it was those negotiations that led to the comments that they were uncomfortable having private meetings with him because we were afraid that his minutes of the meeting might misconstrue what was discussed between them. So again, while it was far from an ideal situation, I saw no reason why, if anything, would appear to be that written communication would be the preference here, just to eliminate the possibility of any ambiguity or interpretation as to what was discussed. So again, the failure to provide in-person meetings was nothing that I saw was required.
Thank you.
Any other commissioner questions for the investigator? Seeing none. Thank you, Bob. So commissioners, you've heard from the parties and the investigator, and at this point, we would be looking for a motion. There's one proposed finding. Commissioner David?
I'll move that there are we find that there's no reasonable grounds to believe that the respondent unlawfully retaliated against the complainant in violation of the Maine Human Rights Act, and the complaint should be dismissed.
Second. So it's been moved and seconded to find no reasonable grounds to believe that unlawful retaliation occurred. Is there any discussion among commissioners? Seeing none. So the motion is to find no reasonable grounds. If you say yes, you are in agreement with that finding. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Excuse.
So the finding is no reasonable grounds, and the commission will send parties and council a letter confirming that. We thank you for participation today.
Amy, I know we're not yet halfway through the hearing agenda, but if we could take a 10-minute break or 5-minute break, I would appreciate that.
Sure, let's take 5 and then we'll come back.
Amy, I couldn't hear the last commissioner's vote.
Oh, it was, he abstained.
Okay, thank you.
Thank you. We'll send a letter to you and your client. Thank you. You're all set.
Thank you. We're now on EDPA 20-0470. And Cassavant versus the University of Maine system. This is a case in which there is a reasonable grounds finding recommended by our investigator, and as a result, we should hear from the respondent or respondent's counsel.
So, Ms. Solcich? Yeah, did I pronounce that right? Solcich. Solcich. Thank you. You have 10 minutes.
Good morning, members of the commission. Thank you for having us here this morning. My name is Jurgen Solcich. I'm Associate General Counsel for Labor and Employment Law, and I represent the University of Maine system in this matter. I'm also accompanied by Gretchen Catlin, Chief General Services Officer and Risk Manager for the University of Maine system. This case concerns, pardon me. This case concerns the university's provision of an optional student health insurance plan during the 2019 and 2020 and 2020-2021 school years. As we stated in our September 30th submission, appealing the investigator's findings, the investigation in this matter was delayed multiple times. Ms. Cassavant filed her complaint on October 28th, 2020. It wasn't until February 11th, 2022, 18 months later, that the MHRC contacted the university for documents and facts, items all relevant to the investigation in this matter. By that point, Ms. Cassavant had appealed the Anthem Insurance Company's findings directly. She had filed a complaint already with the State of Maine Bureau of Insurance. All of that information went to the investigator and was reviewed before consulting with the university at all as to what the facts were in this case. At the outset, it is crucial to establish the fact that Anthem, the insurance company, initially denied coverage of the medical procedures at issue in this case, not the University of Maine.
I'm sorry to interrupt you. Could you not use the name of that third party? We gave them a pseudonym in our report. So if you want to call me insurance company, the insurer, whatever.
Duly noted.
Thanks.
The University of Maine system is not an insurance company and should not be held liable for the actions of a corporate third party that has no legal affiliation with the University of Maine system. We respectfully request that the commission credit the record evidence and UMS equal opportunity investigator Angela Tisson's
Third party name. So please don't use that either.
The investigator at the University of Maine system found, quote, Ms. Cassavant was not required to enroll in the Anthem Health Plan as a condition of her access to any university program or activity. Ms. Cassavant was not treated differently or otherwise discriminated against by the University of Maine system. Moreover, the law cited by the investigator Byrne in the report, an act to protect health care coverage for Maine families, which was signed into law by Governor Mills on March 19th, 2019, regulates insurance companies, not universities. The university did not require Ms. Cassavant or any other student to enroll in the insurance plan. For the 2019 to 2020 school year, UMS required proof of health insurance coverage. And that coverage would come under a plan of the student's choice. The Affordable Care Act of 2010 allows dependent children age 26 and under to enroll in their parents' health care plan. And during the Issues and Resolutions Conference, Ms. Cassavant's mother testified that the health insurance plan that she and her husband subscribed to did not, in fact, cover gender-affirming health care for their dependents or for anyone on their plan. Moreover, Ms. Cassavant had her choice of healthcare coverage through the State of Maine's Healthcare Exchange. Any Maine resident has the option of choosing the healthcare plan that best meets their needs by visiting the State of Maine Department of Health and Human Services Office of the Health Insurance Marketplace website. The investigation did not establish that the student health insurance plan was the only option for Ms. Cassavant or any other student at the University of Maine system. The real issue at hand in this case is an insurance company's initial denial of coverage for certain medical procedures. The University of Maine system is not an insurance company. The university is not responsible for the actions of an unaffiliated insurance company, and it defies logic that it would be held liable for the actions of that separate third party. We respectfully request that the commission overturn the reasonable grounds finding as to the University of Maine system, and we restate all of the arguments previously submitted in both our September 30th, 2022 submission and the April 29th, 2022 submission by the investigator for the University of Maine system. Thank you.
Thank you. Hold on, I'm going to see if commissioners have any questions for you.
I beg your pardon.
Questions for response?
I do. Hi. I'm interested in the portion of your argument in your response where you indicate that the complainant has prevailed subsequent to this case's commencement, has prevailed in her appeals to the insurer such that the procedures were in fact ultimately were deemed to be covered by the insurer. First of all, that's in the record?
It is, yes.
And is that for both procedures? There were two separate procedures. I wouldn't dream of pronouncing them, but there were two separate procedures.
It's our understanding that the chondrolaryngoplasty, which is now also known that's a count. Which is also known as a tracheal shave, was eventually covered by the insurance company following Ms. Cassavant's appeals to the insurance company. It's also our understanding that vocal feminization surgery, again, was initially denied by the insurance company, and then following a successful appeal that Ms. Cassavant and her family were reimbursed for the cost of that procedure.
I'm going to ask this question of the complainant too, probably, but help me understand. Whether you agree with it or not, you understand that the complainant's complaint is that the university chose an insurance company that didn't provide for these services, even though they were medically necessary. You understand that's the complaint, correct?
I understand that that is the complaint.
But
yes.
if these appeals were successful, isn't it factually accurate to say that this insurance company at that time, under this policy, in fact, did provide coverage for that, for those procedures? I mean, admittedly, after an appeal, but someone had to interpret it, fair enough, went off to someone to interpret it, and ultimately, the final arbiter of that decision decided that, in fact, this policy at that time, on that day, covered these retroactively, admittedly, finding, but cover, and that the complaint is not out of pocket anything.
With regard to your question, I agree that the insurance company did ultimately cover the procedures at issue. I can't speak to the complainant's out-of-pocket costs. I don't have firsthand knowledge of what those costs are.
Fair enough.
But based on the record evidence that was submitted to the investigator, it appears that their appeals, which were submitted with the help of an advocacy group, a healthcare consumer advocacy group based here in Maine, that they were ultimately successful in getting those procedures covered by the insurance company. And moreover, the University of Maine system supports Ms. Cassavant and all gender non-conforming students at the university. This is not about Ms. Cassavant's identity in any way. We are very supportive of any student, any member of our community who seeks the healthcare that they need.
So I'm going to ask this question also probably of complainant, but at the time that she was complaining that the university was not giving her an option of an insurer that found these procedures to be medically necessary and thus covered, does the record show that she did in fact, was she able to in fact identify any insurance company that provided for coverage of these procedures as being medically necessary? If the record shows that.
The complainant did not submit evidence of her efforts to research alternative health insurance options during the pendency of these proceedings.
Is it possible that at that time, at least at that time, There was no insurance company in the world that would provide for these being medically necessary.
It's certainly possible, but that is not the assertion that the complainant made.
Well, again, I'll ask it of the complainant, but shouldn't the complainant have to at least show that there was in fact an alternative? The policy that the university did offer, that the university wasn't choosing and therefore was discriminating against the complainant.
To break up that question a little bit, the university required students to provide proof of insurance. That was the requirement for the 2019-2020 school year. It was every student's option, their option, to choose a healthcare plan that fit their needs. The university partnered with an insurance company to offer a plan. But every student had the option to enroll in whichever plan that they liked, whether it was through the healthcare exchange, whether it was through a plan that they might qualify for under their parents' plan pursuant to the Affordable Care Act. Because any dependent child, age 26 or under, has the right to participate in their parents' healthcare plan, and that's been the law of the land since 2010.
Right, I don't want to interrupt you, but I guess I do, I did. I get that point. I guess my point is a finer one, and that is, and maybe this is a question for the complainant, but if the complainant can't show that at the time they were complaining of this failing on the part of the university, that there in fact existed on the face of the planet somewhere an insurance policy that did provide for this, then the complainant's claim must fail, correct?
I agree. I agree that the complainant's claim must fail.
And was there any discussion about that in the fact finding or anything that you know of? Was there any suggestion that there in fact existed a plan that would cover these procedures?
I mean, the investigator did not ask complainant about her efforts to research other healthcare plans. That was something that was not covered during the investigatory hearing. And it's our position that that should have been a question that was asked during the hearing.
I have no further questions. Thank you.
What about the university's investigation of other healthcare plans? Did you investigate other healthcare plans when you found that these services that are medically necessary were not provided in what you were offering?
If it's in the record.
Yeah.
So I personally, not me personally, but our risk manager, Gretchen Catlin, could speak to that more thoroughly. It was her office's role to research the various health insurance plans available. The insurance plan that the university ultimately chose was determined to provide quality preventative care for students while keeping deductibles low. And that was the reason why they went with that plan.
You've said several times that the Affordable Care Act allows a student to be covered under a parent's plan, but I mean, obviously the student could have no living parents, could have no other option other than this plan. That doesn't seem to me a significant.
This, respectfully,
Yeah.
Commissioner, in this case, the complainant's mother actually testified during the investigation that her and her spouse's plan did not cover these procedures either. But in the situation that you discussed, where there might be a student who has no living parents or is not a dependent of their parent or guardian. Again, there is the option to pursue any health insurance coverage that they qualify for by using the state's health insurance exchange website. Anyone who wants health insurance coverage and use that website to find a plan that fits their needs.
There's mention of the cost. There's a cost to the student, correct?
Yes.
And I don't think it says what it is, or is there a quantitative comparison as to whatever that cost is to something under the Affordable Care Plan or some other comparable coverage?
I mean, there are multiple plans available under the health insurance exchange. Are you asking about?
I'm asking if this isn't so very substantially cheaper for students than comparable coverage on the open market. this is a benefit for students that the university wants to give its students, is it
It
not?
is an optional benefit. It is not required to enroll.
But it is a benefit and it's a substantial benefit, is it not?
If the record says.
Right, well, that's why I asked about the cost. It says it's low cost. I can see that the university wants it because it covers the clinic, which other policies might not, and it covers sports injuries without limitation because at the university, that's a valuable thing. But it doesn't cover these. It's a full service plan, right? It
Correct.
covers all kinds of medical procedures. It's not just an accident and disability plan.
Correct, it's a health insurance plan.
Okay.
Not just a catastrophic.
Right, and so what I'm trying to find, and I think I'm hearing that it's not in the record, is a qualitative comparison of how much of a benefit this is financially to students of the University of Maine from what it would cost to get other coverage. Not in the record?
We did submit documents into the record where we summarize the plan that the university ultimately chose. I do not believe it's in the record in terms of that. I believe what you're asking about is sort of a side-by-side comparison.
Yeah.
And that is not in the record.
Side-by-side comparison to what though? Did complainant propose a plan that covered these procedures as medically necessary? And then say that it was more expensive than the one the university was offering, and therefore they were being discriminated against.
No, the complainant has never offered a comparable plan that covers the procedures at issue. They have not pointed to a comparable plan that would have covered them when they first sought the coverage for those procedures.
And I think I did see in the record, in the investigator's report, some figure in the neighborhood of $2,000 a year, but I can't find it now. Does that ring a bell for you? Or we'll find it before we're done today, I think. That's fine. I'm not sure if that's important. I'll keep looking while we hear from the complainant.
Are there other questions for respondent at this time? Seeing none, Ms. Salsa, did I do it right that time? Yes. You have about 5 minutes left when we come back to you. Thank you. Thank you. So now we're going to hear from Ms. Cassavant. This is not complainant, but I believe complainant's mother. And again, I'm going to remind folks not to use the names of any individuals who are not parties to the case or.
Good morning. I'm Susan Cassavant. I'm here representing my daughter, Ann Cassavant, a student at the University of Maine system. I'd like to state that we agree with the investigator's findings and disagree with the respondent's representation of facts and conclusions. I am, of course, not an attorney. We couldn't afford an attorney, after scraping together $50,000 pay for our daughter's medical expenses out of pocket. We have subsequently been reimbursed at approximately 80% after a 2.5-year fight with the insurance company or the university's chosen insurance company. I have been a stay-at-home mom for 20 years. My husband's retired military and VA disabled, live on a fixed income. So pick and choose where you want to put your money. My daughter's health and mental health and the risk to her life came first. Why, our income is limited. I've been a stay-at-home mom for a very long time. I do have time to fight for my daughter's medical needs and time to fight for her rights. The university disregarded my daughter's needs and rights and put her life at risk and caused great stress to our family. It seems to me, in my limited understanding, that the respondent included a number of red herrings in their response to you. They repeatedly mentioned time delays that were out of our control. They said that we've been reimbursed without consideration for that time effort, and distress we suffered to finally receive coverage that was illegally denied to us for more than 2 years. They state that my daughter was eligible for other insurance, but that is technically not true. Because TRICARE has advised us in writing that technically they are not an insurance company, but insurance by mandate.
Not use the names of other coverage.
Well, that company is not, or not really a company, is not subject to the Affordable Care Act and the protections that the Affordable Care Act offer to transgender people. And they're subsequently also apparently not subject to the laws of Maine. The UMS also complained that we did not list the insurance company in our complaint to HRC. I did not do that because it was my understanding, be it limited, that you didn't have jurisdiction over the insurance company and that fell under the Maine Bureau of Insurance. And we have filed multiple complaints with the Maine Bureau of Insurance over the past 2.5 years. The university claimed that they serve 30,000 students, which means statistically they have at least 500 transgender students, probably much higher. Yet the needs of all transgender students were ignored in the university's decision-making. UMS claimed that they do not discriminate, but they showed complete disregard for our allegations of discrimination in their chosen student health insurance plan. As a place of public accommodation, they have a duty not to discriminate against a protected class, even indirectly. We did not file this complaint during my daughter's first year of being discriminated against by the university's plan. First, we went to the university, naively assuming that they would have an interest in the fact that their policy discriminated. And I would like to state here too, that this was not just a denial of coverage based on medical necessity. This was a denial of coverage based on medical necessity, which they had a blanket list of exclusions in their policy that for transgender people, all these things are cosmetic. All these things are not covered. That's illegal under Maine law and under the Affordable Care Act. And I did try to pursue that with the Maine Bureau of Insurance. And I tried to find an attorney that would take it pro bono, but unsuccessfully so far. So anyway, the first year we did not file a complaint with the HRC. We went to the school. I spoke directly with Gretchen Caitlin. I provided her with some documentation, which I had, an ethics article.
I'm going to encourage folks, I know Ms. Catlin is here, so identified. I'm going to encourage folks not to use her name. We can
So
her pseudonym.
with the risk management, I believe she's the director now. I don't think she's the director. So with the risk management person at the school, that it took me practically 6 months to track down who to even possibly talk to at the school without the insurance. That was a whole nother incredible headache. They don't make this information available publicly. So anyways, we put them on notice. I sent her an email. I sent her supporting documentation, including a benefits magazine article that was written by a number of attorneys that said that, employers could be liable. And I guess they thought since they're a school, it has nothing to do with them, but it had to do with the general idea of liability and blanket exclusion thing in policies. And that has been found to be illegal specifically in multiple states. So anyway, they admitted that they did not even discuss the allegation of discrimination with the parties that had to vote on choosing a policy for the following year. So they put it out for a vote. They said, oh, we'll get all this coverage for our athletes and the cost is good. But they didn't even tell the people who voted. There's probably people out there feeling sick to their stomachs if they found out about this, that they voted for this policy without knowing that we had alleged discrimination, without knowing that that was out there, that those blanket exclusions were part of that policy. So they didn't even mention that to the people that voted. The university continues to refuse to recognize Maine law, which states under Act 5 MHRC 4553, and this is my understanding, participating in a contractual or other arrangement, or relationship that has the effect of subjecting the covered entity's qualified applicant or employee to the discrimination prohibited by this act. A relationship includes a relationship with an organization that provides fringe benefits. UMS has repeatedly denied liability for their choice and benefits they provide, though they have not denied that the policy they chose discriminates. They admitted under investigation that they could have requested changes to the insurance policy. Specifically, they considered cost and coverage for athletes. They stated they considered the cost for the athletes, not a protected class, but they didn't even consider the issues for the transgender students who are protected class. They provided no evidence of increased cost. There may have been, but they provided no evidence because I've not been provided any evidence that they even asked about it. It's that the discriminatory exclusions be removed. They never even asked the insurance company how much these changes would cost. In a final investigative interview in May of this year, the UMS director of risk management stated she did not even know if Anthem continued to discriminate. She's not bothered to look into it after more than 2 years. Her only concern was liability. We ask that you tell them that they are liable. In closing, I ask that you confirm the investigator's recommendation that there are reasonable grounds to believe the University of Maine system discriminated against my daughter and all of their transgender students. The university system cannot continue to believe they have no liability for their choice to ignore discrimination in their chosen benefits, their choice to ignore the rights of their transgender students. Thank you.
Any questions for Ms. Costigan?
Yes, I'm just following up on my earlier questioning of the respondent. Do you agree that in order for your case to be successful, do you agree that you need to have provided a non-discriminatory alternative to the plan used by the university? And if so, I don't know what the record suggested. If the record suggested, did you folks say to the university that this other plan that you guys could follow, that you could use as in fact one that would cover these procedures?
Well, it's two-part. Yeah. So I did consider going with another insurance company because my daughter's doctor had told her, if you switch to Harvard Pilgrim, to another company in the state of Maine, available, these things are covered.
Okay, that's my question. Is that something that's in the record?
No,
Did you know
nobody ever asked me about that. And I didn't focus on it because
I'm sorry, the investigator and commission counsel assistant are telling me that there is something in the record about
Yes,
that.
sir.
Yes, and the investigator will be answering
Okay, the
questions.
investigator
So we can reference what that is. Okay, so anyway, I looked at it to a limited extent and it was more expensive. And the other thing was that I really believed that because of Maine law being clear on non-discrimination, so the insurance company was basing their denial on a discriminatory insurance policy, not just saying, oh, we don't think it's medically necessary. We don't think it's medically necessary because we've included all these exclusions. Those exclusions were illegal. So I really felt that I should fight for them to be covered. That all these other students don't have moms that are stay-at-home moms that'll spend 10 or 20 hours a week fighting for their needs. How are they supposed to get covered for anything? I mean, so it was, what was being done was illegal in my book. And I was determined to continue to fight to have that covered. And I will tell you that even though the director of insurance wasn't aware of it, that ultimately Anthem, apparently she did not ask and wasn't aware that they had changed their policy. They did change their policy in May of 2021.
That's what the investigative report reflects.
And but the school wasn't even interested in that. All they cared about was, well, are we liable? We don't care what's happening to you and your family and if you're being discriminated against. And if all our transgender students are being discriminated against, we only care if we're liable for it. And then the other thing that you had mentioned about benefits, I mean, it's my understanding that benefits should be equal to everybody to all the students of this college. And that was a benefit, a reduced insurance cost. And but it did not apply to my daughter because they had a special exclusion that had been struck down over half the country already, those blanket exclusions that were listed in that insurance policy.
Mr. David?
Am I correct that what you're saying is that you are in that category in which you didn't have another insurance plan available because she's your daughter under age 26? I mean,
Okay.
because the other entity that covers your husband wouldn't cover her as a dependent?
Technically, well, that,
Let's-
without saying the
Only
name,
what's
that
in
is
the
very
record.
difficult.
Let's keep it to what's in the record.
But isn't that in the record?
I don't know.
Okay, so I think it is. Well, it may not be. So
The investigator says it is.
it is. Okay, so technically, my daughter can get insurance or we get insurance through my husband's policy with the military. But apparently, when I say military,
You can say military. Yes.
So technically, though, we found out through denials from the military insurance that they are not actually insurance. They are, or a health insurance policy. They're not regulated by the Affordable Care Act. They are insurance by mandate, and coverages can only be changed by a change in the law,
And they wouldn't cover either.
and they would not cover. Yes.
And is it the case that because of this situation, she actually did enroll in the university?
Right, that's why we went out and got separate coverage, and I thought, oh, it'll be covered, because main law says it has to be covered. If it's medically necessary, it has to be
Did
covered.
she enroll in the university plan?
Yes, yes.
Yes, okay, all right, and then took the appeal, which is eventually successful.
And another appeal, and it was 2.5 years.
That's 2.5 years, right?
Yes.
And it's only, well, we don't know what the 80%. Doesn't matter, okay. No, that's all, thank you.
Any other questions for commissioners? Okay, seeing none, you'll have about a minute left when we come back.
Okay.
And now Ms. Selfick. Have about 5 minutes.
Thank you, commissioners. We maintain that the university did not discriminate against Ms. Cassavant in any way. During the question and answer that just happened, the testimony established that Ms. Cassavant had other insurance options aside from the SHIP. And the record evidence in some has shown that the procedures were ultimately covered by the insurance plan that Ms. Cassavant chose. There is simply no nexus between the initial denial of coverage by the insurance company and Ms. Cassavant's relationship as a student at USM. We, again, are not an insurance company. Ms. Cassavant had her choice of insurance plans. She was not obligated to enroll in the SHIP. And the facts have established that she has been successful in her appeals to the insurance company to get the medical care that she needs. We maintain all of the arguments that we submitted through the April 29th and September 30th submissions. And we take issue with the complainant's mother's assertion that we don't care about transgender students. We have a very rich community of students, faculty, staff, many of whom identify as transgender. It is upsetting to hear that the university would be painted with such a broad brush based on the actions of an insurance company. We care deeply about our students. We care deeply about our community. We are supportive of Ms. Cassavant's efforts to get the healthcare she needs. We are not a healthcare provider. We are not an insurance company. And this matter honestly has become quite convoluted throughout the process, and we empathize, of course, with the appeal process and how long it took to get these procedures ultimately covered by the SHIP. But there is simply no evidence in the record to suggest or conclude that the University of Maine system discriminated against Ms. Cassavant in any way.
That's the end of your statement.
Yes.
Commissioner Day.
You said a couple of times that you support her and you support the students that are in this situation. Did you try to negotiate with the company to provide this coverage in the next year? In other words, you say you're not an insurance company, but you're not one customer. You're 30,000 customers. You've got some leverage, do you not?
We are a large customer, and the record has also showed that the insurance company has changed their policies to now cover these procedures as of May 2021. And so
If it's in the record, I'm asking you directly in response to this case, did you try to negotiate for her? When you received that initial denial of coverage in 2019 that they wouldn't cover it, did you go to them and say, what's it going to cost? How can we change the policy? How can we make it right the next year? Or did they do that on their own? Or is it not in the record?
the student, I mean, when a student enters into a dispute with an insurance company, those conversations are private, those are confidential between the student, their healthcare providers, and the insurance company. The record actually establishes that Ms. Cassavant did not copy us on any of the appeal process. Any of the appeals that went to the insurance company, to the reviewer, we didn't receive copies of any of that. And so it seems that the complainant is trying to hold us responsible for a process that we were not even party to. Those appeals all flowed through the insurance company and the reviewer.
Is it still the case that the insurance is mandatory? That there's a requirement that they have insurance of some sort? Students have insurance?
There is no requirement.
So that's a change.
It is a change. And that was made partly due to the fact that the administrative burden associated with verifying coverage for 25 to 30,000 students in any given year is considerable. Like many other large employers, as a result of the pandemic, we are very short-staffed at the University of Maine.
So even if it's not mandatory, is it still available? Is there still a ship that's available that is at very much reduced cost?
The ship is still an option for our students.
I'm not sure if the current status is in the record.
It's just the reduced cost.
The reduced cost.
Yes. Yeah,
Thank
that's
you.
all. Thank you.
Any other questions for respondent? Seeing none, thank you. Thank you. Cassavant, you have about a minute left.
Well, first of all, as I said, it's not discrimination to be denied medically necessary care for 2.5 years under blanket exclusions that the Maine law says are not allowed. Blanket exclusions are not allowed because each case should be individual. We had to show my daughter's medical necessity specifically to her. And I did argue that it's on the record that effectively, and I don't even know if it's relevant, policy was voluntary or mandatory, but I argued that it was effectively mandatory based on, not only just based on cost, but also on enrollment periods. You know, you have to enroll by a certain time during the year. Well, the school's time period is August 1st to August 1st, but every other healthcare is what, mid-November, December, starts on January 1st to January 1st. How do you overlap that? We would have had to bought a separate policy ahead of time, paid all that money out, then submitted the documentation to the school to wait and see if they would approve that insurance policy or not. So that's okay.
Hold on, there may be questions, hold on.
I have a question, but just give me a moment to find what I'm looking for. Please.
I have a question as to whether you thought about going to law school.
Yeah.
I regret not going to law school at this time. I did get my master's in business and I just really wasted my time. I should have.
I'm looking for we have these investigative reports with us, and they're heavily footnoted, and I'm looking for information that I thought I'd highlighted. But when was it? When did you folks provide proof, either to the respondent and probably to the insurer, that these procedures were medically necessary? It was in 2021, wasn't it? Maybe.
No. Originally, well, something that never got touched on here is that my daughter has actually had more procedures under the same insurance policy. And so there have been more procedures paid for. But originally she had her surgery in September of 2019. We weren't able to get any assistance with finding providers, which is also a problem in the state of Maine. Most stuff's not available in Maine. You have to go outside. So she had her surgery. We just went ahead and paid for it because we couldn't get the insurance company to even respond to us, much less tell us if it would be covered or not. And we felt like, you know, this is life-saving surgery for my daughter.
And she was a student at that
She
time.
was a student at that time. So we paid for the first surgery. We filed it with the insurance company. We provided we had all the medically necessary, all the letters from multiple doctors saying that this is medically necessary for her specifically. And under Maine law, that should have been enough. There shouldn't have been blanket exclusions in an insurance policy that says, we don't care if it's medically necessary. We're not covering it. So yeah, we provided, but we didn't, and we provided everything when I contacted the school. As I said, it was a long, arduous process trying to get in touch with somebody at the school. I spent days and days and days calling, and they said, call this person and call that person, call this person, to finally figure out. I don't know how the whole school thing is structured, that there was a risk management department with the state, and finally got in touch with somebody there after months of trying. And then when I did get in touch with the risk management department, and I have emails documenting that in the record, I explained to them everything, that the claims had been denied under not medically necessary, but they were denying it under an illegal blanket exclusion. And I sent also a copy of a Benefits Magazine article indicating how those blanket exclusions are discrimination. And I sent a copy of an Endocrine Society article about ethics in medicine that I sent to them. And I would have sent them anything they asked for. I'm not for sure if I thought that I had probably at some point sent them a copy of, I think at least my complaint to the Bureau of Insurance about the denial. I mean, I can't swear to that, but I would have sent them anything that they asked for if they had any interest, but they didn't. They said, you go ahead and keep appealing and we'll look into it. And then but as far as my understanding and any information I've been provided, they never looked into it. They didn't care. They only cared, are we liable for this? They didn't care that the discrimination was occurring. Mr. Ashby, please.
Well, I found what I was looking for. You're correct. Well, I'm assuming you're correct, but that the reference to the procedure being medically necessary it was some correspondence in September and in November 2021, but it's related to your appeal. But you're suggesting that in fact that someone indicated, of course, it was medically necessary at the time of the surgery. So that was way back.
Right. And they did, because they went back and paid it, because Maine law told them my many complaints with the Bureau of Insurance, they were instructed. I didn't just win an appeal. I lost the first appeal. I lost the second appeal because they're basing this on their exclusions, which are illegal. I didn't win until I filed the final complaint through the Bureau of Insurance, and the state instructed them that they could not do that and they had to pay. And then after that, they did coincidentally change their policy. So 2 years, and the school coincidentally changed their requirement for insurance, which I'm not sure is really valid. I mean, I don't know really what voluntary or involuntary, if that's really illegal. Okay.
I think the commission was all set with this.
Thank you.
Did you have something?
I have a question for council. Is there any timeline problem here when statutes were amended to affirm, gender identity discrimination? I mean, was that in effect at the relevant time periods here? In
Absolutely, it's
2019?
been in effect for more than 15 years.
Yeah, okay.
Thank you. And we are finished hearing from the parties.
I do believe that question was for
counsel, for me.
For her. I
the
beg your
audience.
pardon. So at this time, we've heard from the parties and now we're going to hear from the investors. Courtney Berg.
Morning, commissioners. My name is Courtney Byrne. I was the investigator assigned to this case. There was a couple things I just wanted to touch on that may have potentially been cleared up in the past few back and forth. But for one, the appeal process. So as complainant's mother was stating, there's 2 internal appeals through the insurance company. And then what ultimately reversed the decision was an external appeal through the state agency. So I just want to make sure we're clear on that. And then another thing I wanted to touch on was I did ask during our issues and resolutions conference if other plans were available to complainant. And that's when the discussion about complainant's parents being retired military and having a benefit that wasn't technically classified as insurance available to them, but unfortunately it also contained discriminatory terms. And then another thing I wanted to flag too, so in complainant's answer, she discussed the fact that open enrollment was not an option because the deadlines for open enrollment were, I believe it was November 1st to December 15th for plan taking effect in January 1st. So the deadline for submitting a waiver to the university was October 1st. So there was the risk of potentially paying for 2 health insurance plans at the same time. So those were 2 things I just wanted to clarify, but if you have any other questions, I'm more than happy to answer those.
I do. The questions that I, hi, by the way, the questions that I had asked both counsel, I want to ask you as well. My questions didn't relate to whether or not the complainant had pursued other policies per se. I mean, I certainly take you at your investigatory finding, and then of course what the complainant says as well. I take you at your word that the policies that they had immediately available to them that were actually available in their household did not cover these procedures. I get that. But did the complainant, in trying to show that the plan offered by the respondent was discriminatory, did the complainant provide proof that, or any evidence that there existed on the face of the planet anyway, a policy that in fact did provide for these procedures as being medically necessary and covered?
So a complainant did reference a plan in one of the submissions. So I believe it was a communication between, it was complainant, and I can't remember for sure if somebody at the school referencing the policy by name saying this policy does cover. So it is in the record, and all those submissions were exchanged.
Right. And that was provided contemporaneously, like at the time of these complaints being made, provided to the respondent and said, hey, this is an option. You can do this one, or you could have.
Yeah.
Could have chosen.
So I'm not entirely sure the specific date. I have to go check the record again to see when that was first referenced, or if that was in communication with somebody at the university, or if that was provided as a submission after this complaint was filed with
And
us.
then relatedly, of course, we get into this discussion about cost. I was mistaken. I don't think there is some, I don't know why I had a figure in mind. It must be a different case, but relatedly, was there any discussion about the comparison in cost between that policy that you say is in the record and the university's policy, the cost to student and the university's policy?
So there wasn't in the record a discussion about costs in between another potential policy and this policy. There was just that concern about potentially having to pay for 2 policies if the plan tried to utilize the.
Because the open enrollment problem.
Right, because the timelines did not line up.
I wanted to draw your attention to page 6, paragraph 7, where it talks about how risk manager acknowledged that they could have requested these procedures be included, but they opted not to, as far as evidence of what could and could not be covered. Just in an effort to clarify this point, I know you've asked everyone, so.
But just want to check that Commissioner Ashby was all done.
Could have requested that they be covered, but they weren't. I'll ask you, I guess, or maybe the investigator.
Mhm.
But ultimately, we know from the record that the respondent, I'm sorry, that the insurance company would have said, no, we're not going to do that. Because it took them all the way to an appeal, right, to ultimately change their mind and to provide that coverage.
We don't know that from the record.
Well, we don't know one way or another, right? I mean,
We don't know because no one asked.
no one asked.
And I would say, let's try to keep our, as much as possible, let's talk to Courtney for right now, and then we'll, further questions with her.
Courtney, hi. You just said that there's no dollar comparison between the other possible plan and this SHIP plan. But there is in the record an indication, and I had asked the attorney for the university who confirmed that what's offered to students is substantially less. It's a major benefit. It's a benefit to students to give them this complete health care plan for whatever dollar amount it is. I thought I'd seen, maybe it was another case, as Jeff said, a dollar amount. There's no dollar amount as to what it costs the students, or is there?
Are you talking about the dollar amount for the plan itself?
For the SHIP plan.
Yeah, I believe so. It was over $2,000, and I can't remember if that's for year, for semester, but I did receive slides as a submission from the university, kind of explaining how different plans were evaluated. And there is a comparison there between a different insurance plan and then the insurance plan that was chosen, but there's not a breakdown of what was covered in terms of gender affirming care in this case.
That's all.
Any additional commissioner questions for the investigator? Seeing none. Thank you, Courtney.
Thank you.
And I didn't mean to interrupt questions for council. Did you have those too? I mean, plenty of time to ask those. But typically at this point, I would say we've heard from the parties and we've heard from the investigator. At this point, we would be looking for a motion. Motion or motions. And there's one proposed finding here.
Just, I'll move that we find that there are reasonable grounds to believe that the university discriminated against a complainant on the basis of sex or sexual orientation, and conciliation should be attempted.
Is there a second? If there is no second, the motion fails for lack of a second.
I'll move that there are no reasonable grounds to believe the University of Maine or the respondent discriminated against the complainant on the basis of sex and sexual orientation. The case should be dismissed.
I'll second. Is there any discussion?
Yeah, I think that the university did in fact provide a policy that ultimately did cover these procedures. After an appeal, but I think that happened. I think that the appeal was the function of the insurance companies' failure to understand that these are medically necessary. It's, my guess is, I don't know this, but it's an evolving area of coverage. Not the issue of whether or not we should be discriminating against people of transgender. That's not the issue. It's whether or not these particular procedures are covered because they're medically necessary or not. Ultimately, they came to that conclusion, which is the right conclusion, in my opinion. And they got there.
Obviously, I'm going to vote against it, but I do just want to say that it seems to be fairly clear that this is was a very substantial benefit for students. That the failure to the university's protests that they care about the students, to the contrary, notwithstanding, they didn't go to bat to deal with the insurance company. It's not the case that the term plan is a fixed thing. You negotiate with insurance companies when you represent 30,000 people. In addition to that, I can think of 4 different ways that the university could have covered this and could have made this right with this student in this situation. The denial for 2.5 years of a benefit that's given to 29,900 other students is clearly discrimination. If you read the definition under the statutes, there it says any benefit or accommodation or, goes on and on and on. It seems clear to me that the university, by insisting on that policy, choosing that policy and say, this is the policy, take it or leave it, that's discriminatory in this situation.
Any additional discussion? So the motion is to find that there are no reasonable grounds to believe that the University of Maine system discriminated against and cast on the basis of sex and sexual orientation or gender identity. If you say yes, you are agreeing with a no reasonable grounds finding. Commissioner Ashby?
Yes.
Commissioner David?
No,
Commissioner O'Brien? Commissioner Walker?
I must abstain.
So the finding is no reasonable grounds, and the commission will send party to council a letter confirming that, and I thank everyone for their participation.
Next is H22-0176AB, AMB, Paula Joy versus Timberline Lodges Condo Association and against the Mountain Valley Property.
Actually, I need to go get her for this one. We do have complainant counsel is here. Thank you.
This is a no reasonable ground case.
It is, yeah.
Thank you for your time, Commissioner.
Thank you.
He said that shit. It's gonna do that.
Hello.
No,
Hi. Have a seat. So we had respondents council on Zoom, and because this is the no reasonable ground recommendation, we will hear from complainant first. If you want to come to the podium, you'll have 10 minutes. And take off your mask when you're presenting.
Oh, I can, excellent, because otherwise I was gonna get the frosty glasses, which never really works. Good afternoon, Commission. My name is Cecilia Glacia, and I represent the complainant Paula Joy. In January of 2021, Paula Joy received her new homeowners association bill. She thought there must be a mistake on the bill because she'd already informed both the respondents that she wanted an accommodation due to personal security reasons, and in fact, had disclosed to the respondents that she had concerns for her personal safety due to her former husband from whom she had suffered domestic abuse. For the next 18 months, Paula Joy explained, both in writing and verbally, to both respondents that she was requesting that an exception be made for her regarding the bundled services for which the association had contracted, using such words as security needs, safety, survivor of domestic violence and abuse, and mental health needs. To trigger a defendant's duty to provide an accommodation, a plaintiff's request must contain sufficient information to place defendant on notice that the request is one for a reasonable accommodation. Plaintiffs do not need to use magic words such as reasonable accommodation. Here, the respondents knew and understood the law around reasonable accommodations because the respondents chose to employ the magic words and phrases of disability law to make a reasonable accommodation when they offered Paula Joy an improvements agreement for her unit based upon the same disability for which she had requested an accommodation regarding telecommunications.
The respondents had more than enough information to understand that Paula Joy was not asking for an accommodation simply because she didn't want to pay an additional fee. The respondents knew, and they now continue to know, that Paula Joy has a recognized disability, yet they continue to deny her her right to a reasonable accommodation. Respondents further contend that they cannot do anything because they have a contract with Spectrum.
Actually, if you could not use the names of any third parties.
Of course, if contract were a defense, this commission would have no work. Federal regulations around telecommunications specifically defer to state agencies, specifically in relationship to disability law. Furthermore, telecommunications companies own the telecommunication company in this situation has a contract that specifically states that the telecommunication company has the discretion to increase or decrease the number of units served. If we were to believe that contract is impervious to disability law, the accommodation requested by Ms. Joy is, we cannot believe that this contract is impervious to disability law. The respondents can simply, but if we are to believe that that is the case, that the contract were impervious, then the respondents could simply pay Ms. Joy's telecommunications bill until such time as they're able to renegotiate a telecommunications contract, one that will hopefully defer to the needs of those within the community who have disabilities. Again, in response to the hand wringing around, but they cannot get out of the contract, I suggest that this is exactly why the Maine Human Rights Commission decision is crucial. Ms. Joy does not have standing to sue the telecommunications company because, as a non-party to a communications agreement, she is not an intended third-party beneficiary of the agreement with standing to challenge that agreement. The association is. Therefore, Ms. Joy is representative of an entire group of people who will always be similarly situated in these types of situations. Associations will vote based upon a majority for particular services. The majority vote will typically override those people with disabilities. The associations will use an excuse for the failure to accommodate the fact that they can't get out of the contract. If the Maine Human Rights Commission finds that the association discriminated against Ms. Joy, which it should, as it is very clear that the association knew and continues to know until this very day and this moment, and they continue to refuse her a reasonable accommodation, then the association may have to pay for Ms. Joy's telecommunications cost. If the association finds that to be burdensome, they have the ability and privity of contract to renegotiate the contract with the telecommunications company. There is a line of cases regarding financial equity for those with disabilities. Here, Ms. Joy is not seeking to pay less than others due to her disability. She is simply seeking to not have to pay more than others due to her disability. Her refusal to pay for services that she cannot use due to her need for a landline that she already has bundled with a telecommunications package has resulted in a lien and will prevent her from the use and enjoyment of her housing. Simply stated, in this case, we have a disability, post-traumatic stress disorder. We have knowledge of that disability on the part of the respondents. We have a refusal to accommodate. We have a de minimis accommodation. We have discrimination. This case could not be quicker. Thank you.
Thank you, Ms. Kasis. Any questions from commissioners for Ms. Leisha? Commissioner O'Brien?
Thank you. If I can make this understandable. My question is, as I understand it, the disability claimed is post-traumatic stress. The first, and I think you're asserting that the association knew that because she had requested security. as a survivor of domestic abuse. So I don't see a nexus, and explain it to me, between the fact that she needed the security and that she had post-traumatic stress, and that was the disability that they're feeling. Am I clear?
Yes, I think you're
Okay.
very clear. Thank you for that question.
Okay.
So my response would be that I think there was an evolution of the language that my client used over time in response to the associations. That's point one. And I think that was in fact because most people who I think suffer from post-traumatic stress disorder, or I think disabilities that tend to be more emotional or mental, don't necessarily come right out at first blush when they're asking for something. They're not thinking about a court case that they're going to have to bring. They're asking something as they know how to bring it in a language that's comfortable to them. So there was a gradual clarification in the language that she used as she understood what it was that she needed to say to them. But I think that language that went from survivor of domestic violence, I need a security camera. And again, the nexus between the security camera is that my client lives up at this condominium year round. She's one of very few people who actually live there year round. She has a diagnosis. I could go into the lengthy history involved, but I don't know that you need all the facts of her mental health, except to say that there also was a nexus with law enforcement due to a court case that she was a victim in, suggesting that she have a security camera. So for her sense of personal safety as a woman alone in a condominium, she needs a security system that relies upon a landline that ties to the local emergency services operator. So over time, she made very clear to them, and I think that the clearest, I think about my time periods here. So we started, something I think began in January 2021. So I believe that in March of that year, a letter was sent on her behalf that clearly described her mental health needs. And again, the language of the law is reasonably knew or should have known. And I also would suggest that there is no mandatory time frame around that knowledge. And in one of my submissions, I actually point to a case that discusses a court that found the respondent's denial and discrimination occurred even within a mediation session within a court hearing, because they still knew, they know, and they're still refusing to accommodate her.
Any other, Mr. David?
Yeah, she's paying for that system, right? That was recommended, the camera and the landline.
Correct.
And she's always paid for it, and she installed it in her condominium.
Correct.
And so what is the association contractual obligation to her in terms of recognizing her disability? What do they have?
Sure, thank you for that question, because they're asking her to pay for services that she cannot use. I guess a helpful analogy.
Well, they're asking her to pay what everybody else is paying, which is $49 a month, because that's what the contract requires 100% participation, right?
Absolutely. And if she didn't have a disability, she wouldn't have an argument. But she has a disability that mandates that she have a landline that connects to an emergency service provider. So she's being asked to pay for services that she cannot use. That's the difference. That's why we're here.
Well, it's not that she cannot use them, it's that she chooses not to use them. That they
She
don't fulfill her need. I mean, she could have both.
She could have both, but I guess a nice analogy would be if someone who was disabled or was hearing or sight impaired, and they couldn't use the telephone service and they had their own system, would you have the same issue? My guess is you would not. She has a disability that in order for her mental health to be protected, she needs that landline Because that is, I mean, if technology changes, then I guess we wouldn't have an issue, but technology hasn't caught up. Unfortunately, technology companies are often motivated to catch up because of cases like this.
And you're suggesting that the condo association, she's a property owner, she owns real estate, she's
Correct.
making her own decisions about that.
Correct?
She's entered into a contractual obligation for an association. You're suggesting that they're in the same status as an employer would be, that she's demanding a reasonable accommodation from. But the association has an obligation to accommodate her as a property owner in that property.
I'm suggesting that the fair house, that what the law says is that nobody can be discriminated against by associations for housing services related to housing. And then there's an extensive list, but here we have a service that's related to housing that everybody who lives in that association is required to pay.
Right,
And
and
she's-
everybody's required to pay it, and you're saying that that's discriminatory because she doesn't want to pay it.
No, I'm saying that's discriminatory because she has a disability, because if our guiding principle was, well, everybody's asked to do this, we would not have any disability laws. We wouldn't have any exemptions or exceptions, because that's a response to everything. Everybody has to do it. She's not asking to pay less. She's asking to not have to pay more.
No, I don't want to
No,
interrupt you. Could she have asked the respondent to pay for her landline as a reasonable accommodation?
Could she have asked the respondent to pay for her landline?
I mean, the presumption being that all of the residents are entitled to safe housing. It's a pretty good case that she arguably has unsafe housing unless she has a landline, but can she ask for the landline to make sure that she has the same enjoyment of her home that folks who don't have her exceptionality or disability have?
She could, in my understanding, and I think you all may have seen the SNL skit about trying to unbundle from certain telecommunications companies, which is funny, but not funny, that it's actually less expensive for her to ask what they're currently asking, what she's currently asking them to do, which is to exempt her, than to pay for the landline, because the landline unbundled, I believe, is $80 versus it's less to them in terms of the dollar value.
But you are getting to the problem of that argument, right? And that is that an accommodation doesn't require a respondent to have unreasonable expenditures to accommodate them.
Correct,
And
but
that's
I
the
don't.
problem we face here in this case, isn't it?
Well, perhaps, except that I would say that the defense of contract is not a legitimate defense, because again, if everybody could argue contract, then we wouldn't have this commission.
Well, isn't the respondent arguing defensive expense?
I think they're saying they can't get out of the contract. They're saying their hands are tied, and I disagree with that conclusion. And the expense, I would argue, is de minimis, and I believe that respondents can be required to pay certain things on behalf of complainants. And in this situation, $49 a month is $588 annually.
Well, one of the arguments you made, in fact, in this case is that you're asking not that your client not have the service of the internet access, but that the respondent pay her fee for her, pay her $49 a month for her, right? Isn't that one of the arguments you make?
I've asked for two things. I've asked for her to be exempted for having to pay the $49 a month.
Right.
So the respondent then, if it's found that she should not have to pay, then it puts it back in the respondent's lap as to how they're going to deal with that. If I were the respondent, I think what I would do is I would go back to the telecommunications company and I would say, hey, we have somebody who cannot use this because of a disability. You need to do something about this. Or I would say, okay, it was found that she has a disability. We're not going to make her pay for something that we as a majority organization voted in. We didn't listen to her because they don't have to, because that's in the declaration. So it's contract. But they also have the ability through the declaration and their bylaws to amend their declaration and their bylaws. So anybody can do, people can be responsive here. There's no lack of ability. There's simply lack of will.
Any additional commissioner questions for Ms. Green? Seeing none, you'll have about 3.5 minutes left after we hear from respondents.
Thank you.
And we have Ms. Eggleston is on Zoom.
Yes, thank you. Good morning, commissioners. My name is Paige Eggleston, and I am representing respondents Timberline Lodges Condominium Association and Mountain Valley Property today. I will try to keep my comments brief and emphasize that the respondents are in full agreement with the investigators' findings in this matter. There are two discrete questions to keep in mind here. Number one, was a reasonable accommodation request made? And if one was made, number two, is that requested accommodation necessary? Complainant alleged in her complaint that a requirement to pay association fees constituted discrimination on the basis of complainant's disability. Notably here, complainant never made a request for an accommodation on the basis of her disability with respect to the payment of her association fees. Further, the requirement that complainant pay her association fees bears no impact on her ability to use and enjoy her home, nor does the payment of the association fees bear an identifiable nexus to complainant's disability. Beginning on November 4th, 2020, complainant made very clear that she did not want to pay the association fees related to the association's cable internet bundle package. At no point during numerous exchanges over more than a year-long period did complainant ever articulate that her request was related to a disability. And to quote specific language, on November 4th, 2020, complainant stated to respondent Mountain Valley Property, "I am living here and do not expect to pay for a service I don't need, want, nor can I use." And in February 2021, complainant wrote to Respondent Association stating that she would not risk losing her job over poor internet service that is outrageously expensive. In subsequent correspondence, there was additionally conversation related to her security system, but I do want to make clear that this complaint is with respect to her association fees. Complainant raised her disability in relation to assessment fees for the first time in her complaint to this commission when she alleged discrimination on the basis of a disability. There are no reasonable grounds, as the investigator appropriately found, to believe that that is the case here. As a separate matter, as mentioned before, and unrelated to complainant's complaint, she had previously made an exterior modification request in February 2022 in order to maintain external security cameras on her property. In that exterior modification request, which Respondent Association encouraged her to submit, complainant articulated her request was on the basis of a disability for the cameras, and that request was granted. Complainant's exterior modification request is separate from this matter. Putting aside the timing of complainant's requests related to the association fees, complainant also fails to demonstrate an identifiable nexus between her requested accommodation and her disability. Respondents fully understand that due to complainant's disability, she requires a security system and cameras at her property. Notably, complainant's security system operates through a landline. The assessment fees at issue in this matter relate to internet and cable services, which are unrelated from the one that complainant uses to operate her security system, a landline. Complainant's disability does not preclude her from being able to use the association contracted cable and internet, and she is also not required to utilize the association contracted internet and cable service. She's free to use any internet service provider she chooses to for her work purposes. And the requirement that she pay an assessment fee related to the association contracted service in no way inhibits her from operating her security system. At no point has she been hindered from doing so, and she does not allege that here. She is simply being required to pay an association fee issued to all association members, which does not adversely impact her ability to use and enjoy her home. I would like to respond to a couple of points that were made by complainant's counsel. With respect to the contract, prior to November 2020, the association had surveyed all unit owners about entering into the contract. They received approximately 80% favorability from the association. It was always intended to be a cable internet package. With respect to landline services, that is typically a service that is managed by unit owners individually based on their particular needs, because they certainly vary. So there has been no expectation of the association incurring responsibility for landline services, nor have they ever been asked to do so. They entered into the contract, and following entering the contract, that is when complainant came forward expressing her unwillingness to pay the association fees. With respect to the association's obligation related to the cameras, if any obligation exists, I would point to the exterior modification request that was granted. Again, that's not the basis of this complaint here, but the association did take that request into consideration and granted it on the basis of a disability. I think that that's the extent of the obligation owed with respect to the cameras. In terms of the analogy that complainant's counsel provides, it is not an analogy. It's certainly an example of how an accommodation request could work, but it does not apply here because there is no nexus to the internet cable services and complainant's stated disability. At this point, I'm happy to take any further questions.
Thank you. Any commissioner questions for respondents? Seeing none, you'll have about 4 minutes when we come back to you, Ms. Eggleston.
Thank you.
Squisha, you have about 3.5 minutes.
Thank you. I just would like to point out again that the record is replete with examples of the timing of my client's requests and description of her disability. I can cite to as early as April 30th, 2021, respondent was in receipt of a written statement that said, I'm aware of Paula's specific safety needs for a secure, reliable alarm system. In July 16th, 2021, it was described as she had a personal history as a survivor of domestic violence. In a letter written in March 2021, her mental health issues were described as the basis for the request. Again, I think the law is that it is a reasonable understanding that someone has a disability, and that's the basis of her request. I think that they reasonably could have understood the basis for her request in this situation. Opposing counsel, respondents counsel, I think is avoiding the issue specifically within complainants exhibit 13. And again, this is the senior director of regulatory law for a telecommunications company that specifically responded to an inquiry about this matter. And I quote, the number of units to receive service under the agreement is negotiated by the complex's management team.
Any
when she made that request for a variance or an accommodation to do the physical modification for the camera because of her disability, correct? She submitted a request to the association.
I know very little about that particular request because I was not involved in it at all.
Well, I
as an
think
attorney.
that's what the record reflects. My question is, could she have asked the association to pay for that?
For the exterior modifications.
Exterior
for the-
modification, yeah, that have a carpenter come and drill holes in the cement and whatever, electrician. Cost $400, you know.
The difference is that she was coming to the association and saying, I want to put something up outside my building.
Because
I
have a
want to do
disability.
this, correct? This situation is the reverse. The association is asking her to pay more, not something more. She already has a bundled landline and internet service package.
But it's
It's
not more than anybody else.
$54. But it is more because on top of what she already has, that is the service she is required to have because she needs a landline to connect to the local emergency service provider. In order for her to unbundle that package, she would then pay $80 a month for landline alone, plus on top of that, the internet provided by the association. Or she can do what she continues to do, and she would end up paying $140. She's being asked to pay more than other people. If she didn't have a disability, we wouldn't be here today. She wouldn't need a landline. She wouldn't need to connect to the local emergency services.
But my problem is what the association's obligation is. I can envision a situation in which her employment requires, from an employer, requires a certain amount of internet capability, and then the employer goes and creates some other contract, and that doesn't accommodate her disability or her TDY or her, accessibility hardware or something like that. That would seem to be a much stronger case if it was an employer that was changing the game and not accommodating for a situation. So I don't see it, but I have trouble seeing what the association's obligation is to her disability. Other than to accommodate, I agree that they needed to accommodate the structural change to install the cameras, but she didn't even think of asking them to pay for it. Why not? Because it's not their problem.
Because in that situation, it's not the associate, it's that the association is creating an obligation on behalf of my client, that if she doesn't fulfill what they're asking her to do, they've liened her property, which eventually can lead to foreclosure. They're denying her her right to live in her own house, and they're asking her to pay more than other people so that she can remain in her own house. If we didn't have an association, we wouldn't be here, and these laws wouldn't apply to associations. I mean, but there are laws that specifically apply to associations, which is why we're here.
Any other commissioner questions for the plan? Seeing none, thank you, Ms. Grace.
Thank you very much.
Ms. Eggleston, you have about 4 minutes.
Thank you. I would just like to provide a quick clarification on the Spectrum contract.
No third party.
I apologize. Thank you. The telecommunications contract, it required full unit participation in order for the association to enter the contract. That was a non-negotiable term, and that occurred in November 2020. During these proceedings following the Issues and Resolutions Conference, respondent Mountain Valley Property did reach out to the telecommunications provider to ask what their reasonable accommodation policy would be if a reasonable accommodation request had been made, hypothetically. And Spectrum indicated that they have no policy in order to accommodate individuals. So the contract is what it is. It was entered into prior to any discussion regarding these assessment fees, but I did want to make clear that those questions have been asked. Thank you.
Thank you. Any commissioner questions for respondent? Seeing none. We've heard from the parties, and at this point we would hear from our investigator, Angela Morris. This is, I believe, her first appearance before the commission. And I would like to note that Commissioner Tom Douglas, one of the 2 new commissioners to join us, is here by Zoom as well. So Angela, take it away.
Great. Well, good morning, Commissioner.
No, we can't hear you. Oh, there you go. Okay.
Can you hear me now?
Yes.
Okay, great. Good morning, Commissioners. In this case, although I certainly emphasize that the traumatic events that the complainant experienced in her personal life, I just couldn't conclude that Timberline Lodges Condo Association or Mountain View Valley Property failed to provide Ms. Joy was a reasonable accommodation. Setting aside the issue of whether or not the association or Mountain Valley reasonably should have known of Ms. Joy's disability. The bulk service fee was not in relation to the disability. The case file did not show that Ms. Joy was deprived of her enjoyment in the use of her housing. she was not impeded from using her landline services, and I can certainly answer any questions that are posed.
Thank you. Any commissioner questions for the investigator? Seeing none. Thank you, Angela. So commissioners, you've heard from the parties and the investigator, and at this point, we will be looking for a motion or motions. There are two proposed findings, one relating to each respondent.
I'll move that we find there are no reasonable grounds on both findings to believe that either respondent discriminated unlawfully against complainant, and the complaints should be dismissed.
That's second. So it's been moved and seconded to find no reasonable grounds to believe that disability discrimination occurred by either respondent. And is there any discussion? Brian?
Well, I'd just say that certainly I am extremely personally empathetic to the situation that required the domestic abuse, which required the security, but I just don't see that nexus. I just don't see that. So I'm going to agree with that.
Commissioner Douglas, did you have something?
Yes, good morning, everyone. Just to add to what was just said, I agree. This seems to be more of a case where we're talking about contract issues, association issues, you know, what's covered in certain contracts versus what's not covered, rather than a discrimination issue. So I'm gonna vote to consistent with the motion that there are no reasonable grounds against either respondent.
Any other discussion among commissioners? Seeing none, the motion is to find no reasonable grounds to believe that unlawful disability discrimination occurred by either respondent. If you agree with that, you will vote yes, both visually and orally. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien? Commissioner Walker?
Abstain.
Commissioner Douglas?
Yes.
Got to see your hand. No, not just like as a wave, but in a vote. Like you're
It was
voting.
up before. Yeah.
Okay.
A bigger
Thank you.
screen, but there it is. Yep.
Thank you. So the vote is 4 in favor of the no reasonable grounds motion, none opposed, and 1 abstention. So the findings are no reasonable grounds. The commission will send a letter to parties and council confirming that, and we thank everyone for their participation today.
Thank you very much.
Thank you. Next is H22-0187. Shama Maiwan, I hope I pronounced that right, versus Adam Naylor. This is a reasonable grounds case, and as a result, we should hear from the respondent or respondent's counsel.
I believe that respondents council is on Zoom.
Yes, I am.
All right, hold on, I'm just trying to find my piece of paper. Yep. Okay, so Mr. Pattershaw, you have 10 minutes.
Thank you. Good morning, commissioners. I represent Adam Naylor in this case, and I want to just bring one issue to the commissioner's attention. This is a finding. This was a split finding. We challenged the finding of reasonable grounds to believe there's discrimination on the basis of sex by creating a hostile housing environment. And up front, I want to say that I am not going to challenge the law on that. I am not 100% sure that Maine has adopted this doctrine, but for purposes of this argument, I'm going to concede that it does apply. I think one of the important facts here is one of the important argument points is to distinguish what is appropriate versus what is discriminatory. And there was a text that my client sent to the claimant that said words to the effect, I would park my car in your garage. And I'm not here to defend that as being appropriate. It's not right. It was said in the context of a discussion about parking. My client intended it as a joke. But the most important point that I can stress is that the claimant in this case also interpreted that as a joke. In her initial submission, which was not in response to anything that we had said, Ms. Maywong wrote that my client made the remark, and it says, my response was, and she wrote, I laughed. It says OF, but I believe she meant to say, I laughed off as a joke. So why that is important is because if you're in the context of a hostile housing environment, there has to be something offensive that's said, something that is unwelcome that's said. That type of response, again, not condoning what was said, but the response was not, I felt that that was an inappropriate comment to make, or I felt that was an unwelcome sexual gesture towards me. So that's the only point I really want to stress is we can't transform what the claimant said was interpreted subjectively as a joke into something that is an unwelcome statement. And so when we look at the investigator's findings, I think it's fair to say that the investigator gave this that statement a fair amount of weight. And so if we take that out of the equation, we have some other, again, not condoning the comments, but some other text in which my client called the claimant babe, sunshine, and toots. Again, not, if I was a landlord, I probably would never refer to my tenants that way. But in this context, we've got the initial statement that was taken as a joke, and then three other texts that use, I would call them probably inappropriate terms of endearment that probably ought not have been said, but they're really not sexual in nature. And so when, again, assuming the law is in Maine allows for this type of claim, there still needs to be a severity or frequency of the statements that were said. And I kind of summarized this in our September 30th submission to the commission. But in this case, I don't think this rises to the level, especially given the way the main comment was accepted, of a hostile work environment discrimination. And I'm happy to answer any questions the commissioners might have.
Thank you.
Sure.
Oh, I'm sorry. Did I interrupt you, Mr. Pattershaw?
No, you did not. Thank you.
Okay. Any commissioner questions for Mr. Pattershaw for respondent? Commissioner David?
What is the significance of if any, of the towing of the vehicle? When is that done?
I think that I'm not sure what the significance of that was. We had discussions at the conference, and I don't know if we submitted any written material on it, but the context of that was there was no ability, I believe my client said there was no ability for him or his wife to move their cars to have ingress or egress to the home in which they live because the claimant had parked her car in that spot. So and I don't remember if the investigator had a finding that was not discriminatory. There were other findings about the attempted eviction, but I would submit it's not significant.
I'm not quite sure who this question goes to, but you attached the complaint of discrimination to your submission, correct?
I attached the particulars of the complaint as Exhibit A to my September 30th submission.
And I guess I have a question for Amy. Who wrote that form? Because part of it is her filling in blanks, and part of it appears to be specific to this case as having been typed as what she believes or not believes.
Right, it is standard. Our investigators handle intake, and if we receive an intake that appears on its face to state the basic elements of a claim, but we don't have all the particulars, if we aren't able to get the particulars from the person submitting it, we will oftentimes prepare a draft complaint
Okay,
and have them fill in the detail.
that's instructive to me, that what's typed in there is the investigator completing a draft complaint based on what's being told
Correct,
to the commission.
correct.
And your counsel, you're pointing to paragraph 3, where she fills in, my response was, I laughed off as a joke, correct?
I am, for the purpose of showing that she did not, I think she would have a better, stronger case if this initial filing said, I found that statement to be offensive. I found it to be unwelcome. And but to laugh it off as a joke speaks to the hostility of it. If it's not accepted as hostile, we can't now transform that into something that was unwelcome. I'm not, again, not saying it's appropriate, but there's a distinction between inappropriate and discriminatory.
Okay, and then you attached some text to your submission, correct?
I did.
I want to ask you about Exhibit B. It's near the top. Thanks you, babe, and then minus babe. Sorry. What do you understand he's doing there?
From what he told me, he believes it could be a typo, but and when he says minus babe, I don't believe he meant to write that, but I can't speak for him. I'm not going to go to the mat saying that that's appropriate.
But what's the next line? You're welcome.
I just think I attached these for examples of the names that were used by my client in certain text messages to the claimant, his tenant. And I think the discussion is about keeping the front door locked. And she said, okay. And he says, thanks, babe. You're welcome. So
and then he
that's the
says, context.
context.
Babe, and she says, you're welcome. And he says, it's okay to call you babe. In other words, it's like he's trying to take back what he knows was inappropriate.
Right, again, distinct. I'm not saying it's appropriate. It could be very inappropriate. The question is this hostile housing environment discrimination?
I understand that. What's the last entry on that page that's half cut off?
Well, she
don't get offended.
That was a submission from the claimant, so I don't know. I don't have the full.
Okay.
I didn't intentionally mean to cut that off. If that's how it came to me.
No questions, Commissioner?
You see at the moment.
Any other questions from commissioners for respondent? Seeing none, you have about 6 minutes left, Mr. Pattershall, but I am not sure if complainant is here at all. I don't see her on the Zoom, and I will tell commissioners that she did contact the investigator this morning, asking if we could reschedule for a different day because she just moved and settled down and got Wi-Fi and is working, and says she didn't know about this meeting until Saturday by email and hadn't received any mail about it. I told her by email this morning that we could not change the date of the hearing because all the evidence that we have is that she did in fact receive both email and mail notices. So we don't have complainants. Mr. Pattershall, did you want to add anything? You have 6 minutes.
Only if there are questions. I think my submission and what I just summarized is the point I'm trying to make here.
So if there are no other questions for respondent, then we would turn to the investigator. Alex Brindley.
Hello, everyone. My name is Alex Brindley. Am I unmuted? Can you hear me okay?
Yeah, we got you.
Good. I wasn't sure. My name is Alex Brindley. I was the investigator assigned to this case. Attorney Pattershall is trying to say that there's like a difference between inappropriate conduct versus discriminatory conduct. In this case, I can absolutely say that this conduct was inappropriate. However, it was also inappropriate to the level that it rised to a level of a hostile housing environment. He also indicated that he refers to the complaint where the complainant indicated that she said she laughed it off as a joke. However, when I questioned her during the Issues and Resolutions Conference, she indicated to me that she did not tell him in these text messages that she found these comments unwelcome because she was fearful of him. She was afraid of him. She felt trapped in this housing because she was, the respondent is her landlord and also lived in the same building as her. So she felt fearful. She felt that should she say that these comments were unwelcome to the respondent, that he would have evicted her. So I believe, at least based on the comment, I would like to park my car in your garage, is itself alone enough to rise to a level of a hostile housing environment. But I am free to answer any questions, should you have any.
Thank you, Alex. Any questions for commissioners for the investigator? Commissioner David.
You agree with his assertion that was in the context of our on the table at the time was another discussion about parking?
Yeah,
And
certainly.
then you said,
That's not a contention here. And I think there was also during the submissions, the respondent indicated that this was meant to be a joke. However, jokes can still be considered sexual harassment. And in this case, I believe it did rise to the level of sexual harassment, causing a hostile housing environment.
Is there any other overtly sexual comment?
Other
like
than,
that?
no, that was the most overt, but we can also refer to the text messages in between the complainant and the respondent, where the complainant, or rather the respondent, called complainant beautiful, toots, babe, as you spoke to Attorney Pattershall about.
Alex, you said that was the most overt. Was there an allegation of any other directly sexual
Other
comment?
than, no. So other than the joke, the comment, I'd like to park my car in your garage, it was just the text messages received from respondents calling her babe, beautiful, toots, sunshine. Those were the comments.
What do you make of the text that I asked counsel about, where he tries to say minus babe, sorry, like he's saying, I didn't mean, I'm apologizing for having called you babe. There's no response to that. It's thanks you, babe. Shouldn't be an S there. Thank you, babe. Oh, minus babe are both his. And then she says, you're welcome. It's something. And I would like to know what's under that. But whatever it is, he says, it's okay to call you babe. So it's like she said, no problem. Don't worry about it.
So
and then she responds again, and I can't read the whole thing. I mean, I don't get offended, I think she's saying. But you're saying that she really was offended?
Yes. I certainly there might be some cognitive dissonance as to what complainant stated in her texts. However, she indicated during the Issues and Resolutions Conference that she stated these texts not because she wasn't harmed by these comments, not that she felt that they were unwelcome, but because she was afraid that if she told the respondent that these comments were unwelcome, that she would be evicted.
When was the comment made about the overtly sexual one that we all agree was?
It was October 7, 2021.
And the towing of the car is in April? The next April?
Yes.
And the eviction is in May for non-payment, right?
Yes.
Thank you.
Any other commissioner questions for the investigator?
Yeah, good morning. This is Tom Douglas here. Morning, Alex.
Morning.
Brindley. I'm a little concerned about the subjective aspect of all of this. And I guess primarily, just for starters, it stems from this intake form that we're looking at, where, you know, the offensive comment is referenced, and she says, I laughed it off. I guess there's like a missing F there, but you know, it seems that the comments during the investigation where she says, I was in fear of being evicted and so on and so forth occurred after that. I'm just wondering what your take is on that.
On the fact that she said that she laughed it off in her complaint?
Yeah, it seems like there's an inconsistency here, right? In her complaint, she says, her intake, she says, I laughed it off, right? And then, later on during the investigation, she's now talking to the Maine Human Rights Commission. She says, "No, I was in fear of being evicted." I mean, can you expand on that a little bit for us?
Certainly, and I can understand why there's like this discontent here. However, when I interviewed the complainant, she over and over indicated that she said that she laughed it off, and she responded to these comments made by respondent in the way that she did so that she wouldn't be evicted, because she believed that if she had told respondent that the comments that he made, the comment, "I'd like to park my car in your garage," or the comments calling her beautiful or sunshine or babe or toots, if she had responded differently and said that she did not appreciate these comments, she was fearful that she would be evicted.
Okay, well, I appreciate that. And then there are some comments here about some things that happened during her tenancy, right? In the winter of 2021, her car is towed for parking in the wrong lot, which is against the lease terms, it says. And then, there's a broken refrigerator, and the respondent, it says, mistakenly did not replace the broken refrigerator, thinking the appliances are not the landlord's responsibility. And then there's a notice to quit for unpaid rent, second notice to quit, also for unpaid rent, and then a notice that the lease would not be renewed. And so I guess I'm wondering, where do all of these events fit in this claim for discrimination? What's the significance of these facts, if any?
Certainly. So in this case, I believed the notices of the notices to quit were her allegation that she was being evicted due to her receipt of public assistance, which you can see in my footnote number 2. I didn't believe that it was in response to her sex. And that claim failed because, the act of evicting a tenant for non-payment of rent is not discrimination, and she had in fact not paid her rent on time.
Okay. All right, and the business with the car, I mean, is it true that she parked in the wrong lot and she was towed appropriately, or?
From what I understand, the complainant had parked in front of so the respondent, the premises had one driveway. So what had happened is the complainant had parked in front of the driveway. And based on testimony that I heard, the respondent was returning home and attempting to park in the driveway, but couldn't because the complainant was parked in front of the driveway.
All right, thank you very much.
Mm-hmm. Thank you.
Any other questions for the investigator? Seeing none. Thank you, Alex.
Thank you.
So the second proposed finding was not objected to. So that one probably should go to adopt since it was not objected to. The first one was objected to. So I don't know if you want to handle those in 2 different motions or how you want to handle that, but those are the 2 proposed findings that we need addressed via motion or motions.
I'll suggest we take them separately, and in the second, I'll take the low hanging fruit. I would propose that we find that there are no reasonable grounds to believe that the respondent discriminated against the claimant on the basis of race and or receipt of public assistance, or retaliated against her for engaging in protected conduct, and that these claims should be dismissed in accordance with the act.
Second.
It's been moved and seconded. Is there any discussion? Seeing none. So the first motion is to find no reasonable grounds to believe that there's discrimination based on race, receipt of public assistance, or MHRC retaliation. If you agree with that, you would say yes. In response to my query, Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner O'Brien. Yes. Commissioner Walker.
Stay.
Commissioner Douglas.
Yes.
Nice job with the hand, good job. Okay, so that is a no reasonable grounds finding. Commissioner David.
I'm going to make a motion that's contrary to the suggested result. I'm going to move that we find that there are no reasonable grounds to believe that respondent discriminated against complainant on the basis of sex, hostile housing environment. That's all I need for that motion.
I'll second. So it's been moved and seconded to find no reasonable grounds to believe that there was a hostile housing environment based on sex. Is there any discussion? Commissioner Ashby and then David.
David, I'm going to vote against your motion. Your right to peace and safety in your own home is inviolate. In my opinion, I think that it can, and in this case does, or is the case, can be, or in this case is the case, that a single statement, in fact, can create a hostile environment. Landlord should know better, and making the statement, I want to park my car in your garage, is enough for him to make very clear what it is he wants, and something that's wholly inappropriate. I think there's at least an even chance that the complainant will prevail in this case. I understand the respondent's counsel's arguments. They're well argued. I do concede that this is one of those cases that's tough. I think you can both pretend to laugh something off and feel that it's a hostile environment. I think that's what happened here in this case. So I think there's at least an even chance, and that it ought to go to conciliation.
I'm the reason that I made the motion is because of the definition that in order to find the discrimination in the hostile housing environment, it's necessary to view all the, I'm quoting the quote from the Doyle case, all the circumstances, including the frequency of discriminatory conduct, its severity, whether it's physically threatening or humiliated or a mere offensive utterance. This is clearly an offensive utterance. It's back in October. I went back and forth. I take notes on these cases and I record my own reaction. And I went back and forth of saying, okay, I agree with my investigator. No, I don't. Yes, I do. No, I don't. And the ultimate conclusion is that I don't think it rises to that standard. And what tipped the scale was reading the complaint in which she says to the investigator that she laughs it off and she makes no complaint to him. And then I look at the text and the investigator is telling me that the text in August in which he calls her a babe is part of a hostile environment that goes all the way through the next year. And she says, I don't mind if you call me babe. I think that's what those texts are saying. That's what I'm finding. So it's a question of meeting that definition of a hostile environment. Whether I agree that the comments are clearly offensive, but I don't think it rises in severity, considering whether it's physically threatening or humiliating. I mean, those things suggest a standard that this one inappropriate offensive comment would not rise to.
Any other discussion among commissioners? Being none. So the motion is to find no reasonable grounds to believe that respondent discriminated on the basis of sex by a hostile housing environment. If you agree with the no reasonable grounds finding, you will say yes. Commissioner Ashby.
No.
Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Abstain.
Commissioner Douglas.
Yes.
So the vote is 3 in favor of a no reasonable grounds finding, 1 opposed, and 1 abstention. So the finding is no reasonable grounds. Both findings are no reasonable grounds. And the commission will confirm that in writing to both parties and council. And we thank folks for participating in the hearing. And I believe that is our last case hearing.
Thank you all.
Thank you. So at this point, we probably need to go into executive session. Do commissioners want to take a break for a couple minutes or launch into it? Commissioner Douglas, how long do we have you for?
Until about 10 of 1.
Well,
I just got here, so I'm gonna defer to the group, whatever you guys want to do.
I'm gonna pee, and since
Well-
I'm the one you need.
Right.
I'm gonna come up, so I'll see you in a minute.
Then I strongly recommend we take.
Looking for a motion to go into executive session.
Are we off mute?
Yes.
Pursuant to 1 MRS section 4056E, I move to go into executive session to consult with our attorney regarding pending and contemplated litigation and the legal rights and duties of the commission.
Is there a second?
Second.
So it's been moved and seconded to go into executive session. Is there any discussion? Seeing none. If you are in favor of going into executive session, you will signify that. Don't put us in there yet.
Poor Jeff.
I know, you will say yes and show it. Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner O'Brien. Yes. Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
He's got that hand right in front. Okay, now we go into executive session. I'll make sure. Anybody else doing that or am I doing it? I'm doing it. I'm doing it. We're going in there. I invited you. Hold B to broadcast your voice. Oh, I don't. Oh.
It's not this yet.
So what are we streaming?
We need to move Tom. I'm making sure, I'm watching YouTube. Go.
Because it claims we're recording and we should turn the recording off.
Amy doesn't like it when we pause it, but I think we should.
I don't care.
I'm not 100%.
Yeah. Right.
But commission meeting should go in there, right?
Right there.
Commission meeting is.
No, but you wanted to make sure it had a big blank thing happening so people could tell it was executive session.
Oh, I don't even remember what I want.
I had to edit a whole video and then re-edit it because of it.
Oh, the one where I screwed up and accidentally.
But you wanted it to, never mind.
Yes, that one, yep.
So, do you hit join or do you want me to?
What?
Yeah. There's a join button. Do I hit that?
Yes, or else you're gonna probably capture.
We need Tom. in a second. Okay. Did you hit the recording button?
All right, I move that we approve the settlement agreement H2O- H2O-0020 A, C, D, and E. What's it, Hobson versus King Real Estate? And that we authorize our executive director and commission counsel to sign that settlement agreement.
Second.
So it's been moved and seconded. Sorry, I was messing around with the pins there and got distracted. We should be showing the whole meeting instead of just Tom's head.
We have the whole meeting.
Okay. Oh, yeah, okay. So there's a motion to approve the post-cause agreement in Hobson versus King Real Estate and to authorize Barbara and or me to sign it. If you're in agreement with that, moved and seconded. I'm sorry, I forgot to ask if there's any discussion. Any discussion among commissioners of that motion? Okay, so if you're in agreement with that motion, I see you, Commissioner Ashby. Commissioner Ashby, yes. Commissioner David.
Yes.
Commissioner O'Brien. Yes. Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Okay. Very exciting. Okay, then we need one more motion.
I move that we approve rule changes, proposed rule changes in well, the main Human Rights Commission rules, chapters 2, 3, 7, and 8, as has been previously presented to us.
So it's been moved and seconded to adopt rule amendments in chapters 2, 3, 7, and 8. Is there any discussion among commissioners? Seeing none, if you're in favor of adopting the proposed, not Barbara, proposed changes in 2, 3, 7, 8, we will say yes.
Yes.
Sure. David,
Yes.
O'Brien, yes. Walker,
Yes.
and Douglas.
Yes.
Okay, that is, I believe.
Thank you, everyone.
I believe that is the last matter of business. And so unless there's anything else.
Thank you all for doing this.
It is agreed, we'll meet in person. Well, we'll have a hybrid meeting next month as well.
I think we're probably gonna have hybrid meetings for some time. And thank you, especially thank you to the staff for helping us make this work. It was really good. And thank you to commissioners for being here. It's really nice to see you in person again. And
I had it on my calendar that it was gonna be Zoom. It's gonna be hybrid in December.
I think for the foreseeable future, they will be hybrid.
Okay, I know I'll be out of town, but I'll be available for the meeting by Zoom.
Yeah.
Great.
All right, move to adjourn.
You don't even need one, but you can have it. Map the table. Anyone? Is there Bye, Tom.